issues which are being connected, such as one very commonly which we find is that someone has copied someone's work is a common allegation which we find. That's the first point. Second one, the Turnitin software or the Turnitin software which provide the result as to how much number of content of your work or what is the percentage of the content of your work is being copied or has the same content in the internet. So these are the two major things which we see and hear, but there are a few more questions which is there attached to it. One, while writing a paper, we generally have a principles during the research methodology. We must have all read and understood in our master degree or in your PhD that whenever you wanted to refer someone's content, you need to provide the reference in the footnote stating that so-and-so quotation, so-and-so content, so-and-so paragraph are being sourced out of the respective article, which is published in so-and-so journal, page number, volume, etc. So this is how we cite them, and there is a separate, citation methods, and we refer them. Why do we refer them and cite? Because no work can be, or most of the circumstances when we write a paper, we back on or we refer and say what previously is being told or what currently is been happening in some places, and that's what the data I'm going to put up. For example, today we all make a study about what post-COVID situation and its impact on MSMEs. Post-COVID situation, impact on the school children's and their studying. Post-COVID situation for teachers in difficulty in teaching. So this, I'm just giving a few examples of titles which you are referring. So when you take an example of post-COVID situation of difficulty in learning for the students, if this is our paper, what do? We see and refer and say that, okay, from past 1.5 years, there has been a greater impact on the education, on the studying, on the regular conduct of the class, or these are all the various parameters you identify. Now you come up with the title is done, you make an abstract, and you come out with an introduction. And in introduction, you say why this is a study about the psychological situation or the learning behavior or various difficulties, etc., etc. You will narrate everything in the introduction, and then you come to a study that, okay, fine, I'm taking the 3 major category of people where I refer to the city people or the rural people or other set of peoples in the state of Karnataka. You would have defined your scope, or you would have said the limitation is only towards the students who are in the degree category or in the school category. So like this, you will define your research methodology by introducing the scope, what is the importance of your study. Your importance of the study showcases that what is the practical difficulties which the students are suffering and how do we cope up. And at the end of your research, you also write that how should the students cope up, or how should the government should cope up, or what is the other methodology should the government come up with, right? So these are all the things you make a usefulness of the study, importance of the study. Then you come up with the problems of the study. What is a problem? Primary problem is about the psychological problem of the students, psychological problem of the parents, management issues, students, educational, primarily the education of a student is being put to jeopardize. So these are all the various problems which you are going to put up. After that, you come up with what? Then you say, okay, fine, my methodology, etc., etc. Then you make a comparative study. Okay, what is a comparative study? Three major layer you take. You take city, rural place, and other areas. So you make a sampling. You collect samples from rural, some 10 people, city 10 people, from there 10 people. Okay, in the due course, you will also refer to the government notifications that, okay, how regularly they are being, postponing the examinations, or telling that this day we are going to conduct, or the other day we are going to conduct. And this causes a huge amount of dilemmas. So you refer to the newspaper articles. Excuse me. So this is how, then after understanding all these things, after making a comparative study, after making literature review, during the literature review, or while analyzing this particular situation, you would have referred in some journal, in some article, or in some book, what is the psychological behavior of a student if he is continuously sitting before the system from morning to evening, or what is his learning capacity. You refer some psychological journals, etc., and etc. And then you also address the problem as the problem which has been stated. The student should not be made to sit before the system morning to evening. Rather, we should give them to analyze, to debate, or to make some other kind of exercises, etc., and etc. are the suggestions and solutions you would have brought out. And then you would have written a conclusion. This is your article, assuming. Is it audible, sir? Santanu, sir, I think there was a network issue from my side. Is it audible right now? Someone puts a chat answers means that they are able to. Yes, good. So in such a way, we are going to
It is audible, sir. You can
yes,
go ahead.
done. Got it. Thank you very much. Thank you. So when we do this kind of work, right? So there is various things which comes into picture. Let me proceed with. So in that circumstances, when you have written this particular article, etc. Now my first slide goes with questions. What is the question which I'm going to pose to you all? That the question of, sir, you write 5-line question. In commerce, we take the economical situation of India, Indian history, and 2-3 other questions you are going to write in a question paper. Okay. And you set the question paper and give it for the examination department to circulate it to the students. And the question is, do you have a copyright over these 5 questions? First question. Second question, that, sir, for the degree students, the faculties would have collected some important articles on economical development of an Indian nation. Some 10 articles they would have collected. Collection of these 10 articles from different journals, some portion from the book, I'm extremely sorry for the internet issue which I am facing. Yeah. I was discussing about the first point is that, sir, we are all preparing a background materials. See, basically copyright is what? Copyright says if someone has done a literary work such as an article, essay, or a compilation, if you have written some kind of a work or a drawing or an article, then such what do you say? Yeah, this so as I was telling you that the reading materials which you have brought out with, okay, which basically, as I said, copyright is a right which has been granted to an author where he does a work. Just a minute, please. As I was telling you that the copyrighted content, copyright says, okay, you are the author of the work of an article you have written. Now, if anyone wants to use your article, they have to take a written permission. According to Copyright Act 1957 of the Indian legislation passed, it says if anyone wants to use your copyright, they have to take a written permission that I'm going to utilize. Now you all write this you all make this compilation of 50 to 100 pages of materials. You circulate it to all your students. Okay, forget it. From past 1.5 years, we are not circulating the materials in a hard copy, but at least sometimes we would have shared the soft copy in the internet today for the class. We would have shared some 5 or 6 important articles for the respective chapter and shared it to the students, right? Now, this is what we have done. Now, my question is this a copyright infringement? Maybe this answer can, sir, one question that the law college are they present in this session? Shesha from law college faculties, are they present in the session? Yes or no? Any chat answers, please? Sheshad from law college students, law college faculties, are they there in this particular session? Shantanu sir? Any other people? Yes, no, nothing? Bhavya madam? Spandana madam, Bhavya madam? Okay, only commerce and management joined today. Okay, done, super. Because the law faculties would be easily, yeah, got it, madam, got it, Soumya ma'am. So if it is law college people, they would have clearly understood because they know the copyright law, they would have read the copyright law, they would have taught the copyright law. Hence, they will be easy to answer. So now, okay, fine, if they are not there, then well and good. Now tell me, sir, such compilation and sharing of materials with your students on the subject matter of your whatever topics which you are teaching to students, is it a copyright infringement? That's the question. Just put up yes or no. Yes. Lokesh sir says yes. Raji sir says yes. Sridhar says yes. Bhavya Prasad sir. So everyone agrees stating that, sir, sharing of, but we can do, but we need to file for copyright. Sindhu madam says that, but we need to file for copyright. Okay. Mukunda sir says yes. Reshma madam says yes. Okay. But a point to be corrected is that Akila madam says yes, it's a copy. Are you telling us yes, sharing of such material is a copyright infringement? Okay, if everyone says that, sir, sharing of such material without the written permission of an author, it amounts to an infringement, is what everyone agree. Okay, good. Sridhar says education purpose, it can be shared. Okay, Sridhar sir comes with another viewpoint. If this is an infringement, then assume how much of materials we have shared and we would have been under a great trouble. Commercial purpose we cannot use. Very good, Mukunda sir. Very good. Yes, any other answers? So what do you mean by commercial purposes? What do you mean by commercial purposes? What do you mean by educational purposes? Commercial purpose is what? Okay, now you go to the what do you say, the Xerox person, book publication, saying the work is mine. Okay, saying the work is mine. No, Bhavya madam, there is a small correction which I wanted to make, that you got the Xerox of the article as it is. You did not put that as it's yours, but compiled the 10 articles and gave it to the students, circulated to the students over email. That's all you have done. That is what you have done. You did not say that it's yours. Monetizing others' work, okay, and is commercial purpose. Open access material with citing can be shared. Okay, sir says another question. No infringement as it is only Xeroxed. Oh, wonderful. Pramod sir says, sir, it is no infringement because I have Xeroxed it. Why? Xeroxing of a material, isn't it an infringement? Now you go to you must have, I think it was in the year 2012 or 10. Okay, when we all used to go to Avenue Road and what do you say, this Brigade Road, our Chetan Bhagat's various books or other various authors' books were Xeroxed, and in a small, it was, yes, it is a same content, made a Xerox in some other low quality material, and it was sold it for 50 rupees and 30 rupees. I remember the books are sold at 30, 40 rupees. And the price of the said book is 200 or 300 or whatever it is, right? So do you feel that, okay, Xeroxing of material, no infringement as it is only Xerox. If I make a Xerox, it does not amount to infringement? Isn't it as regular course of business? That is, sir, if my book would have sold for 200 and some other person is selling for 50 rupees, the same book, okay, by Xeroxing it in a low quality papers, isn't it an infringement? Yes. Photocopying amounts to infringement. Yes, Sridhar agrees. Yes, it is an infringement, sir. Then Sindhu madam says no infringement in case of photocopy, citation of circulation of another author. In case of photocopy, circulation of other authors. Okay. So what do? You go to the, what do you say, some famous author who is there who have written on Indian economics, okay, or a person who have written on statistical analysis. That book, you get it Xeroxed, okay. The book cost around 1,500 or 700. Even during my studying in LLB, or even if you have studied in bachelor's or in master's, you people would have gone to the Xerox shop for the book which you have procured from the library, and purchasing of the said book would have costed you around 500 to 800,000 rupees. So what do? Xerox the important content or important that which is getting within 50 rupees or 100 rupees or 150 rupees, right? This you would have done. So if this you have done and circulated for 50 to 100 rupees, isn't it the author's regular course of business? Sir, if you would have gone to the bookshop and purchased the 800 and 900 book, okay, then the author would have got the royalty or the publisher would have got the money. But today what you do, you take 3 books for the library and the 5-year and the same book is being xeroxed by another 150, 200 people, students in the class per year, or say 50 to 80, 3 years you consider around the same book is being xeroxed for around 200 to 250 times. If the book is xeroxed for 200 or 200 times, isn't it my regular course? I have written the book and you get it xeroxed for 200 times and give it to the students, and only 3 books sold. If 20 books have been sold, how much would have got? Isn't it in such circumstances, though it is not for commercial purposes, but it has affected my regular course of business, right? Isn't it then an infringement? Is a question which we all have to think of. Okay, Sindhu madam has given some kind of an answer. If materials are photocopied and sold, then it's infringement. But if it is shared only for knowledge purposes, it is not infringement. Okay, madam, I agree. Fine. Now you download this particular book in the internet. Now let us discuss about the digital world. Now you have hard copy is gone long time back, but today you pay 500 rupees for the book, you download it. But your friends and colleagues or other college people or other students wants the book. Will you share it? You share it because you say it is for knowledge purpose and I did not ask for money to anyone. But does this amount to an infringement is my question. Yes, I open up this particular debate to all others who are there in this particular group. My simple question is, as the argument proposed by Professor Sindhu madam that the material are photocopied and sold, then it is an infringement. But I have received the book or the material in a soft copy, I have paid money, full money, but I have made a soft copy of the book. Now I share it to whoever asks me, or I upload it. Okay, first question is I share it to whoever asks me, or to all our 60 students and other colleagues, etc., etc. I email everyone. I also do put in my Facebook. I also put the same link or the book material in the Facebook, in the Instagram, etc. for anyone to use, because knowledge is for everyone, you know. We have to share. Now tell me, is this or does this amount to an infringement? Is a question. Quickly, please. Sridhar sir says yes. Next. What about Mahalakshmi madam? Mukunda sir says yes. Unauthorized use is also infringement. So sir says, sir, no commercial gain. The unauthorization, what is that? Authorization and unauthorization, 2 points he is referring to. 1, did the author authorize you to circulate? No. Then why are you circulating? So it amounts to an infringement according to Mukunda sir. Yes, another 2 or 3 responses I require. Please don't just say yes or no. Add one more point of your justification. Why are you going to say that yes, it amounts to infringement, or why are you going to say that no, it does not amount to an infringement? Owner name is there, sir. Okay, madam, just merely because the owner name is there, can you simply circulate? Mr. Lokesh sir, you say owner name is there, but as it is, I am putting sir book. I am not putting, I am not removing Mr. Vivekanand sir, Vivekanand name in the book and putting Lokesh. I am putting as the book as it is for everyone's circulation. That's all I have done. So sir says it does not amount to an infringement. Anyone else? Anyone? I'll just go to Sindhu madam. You can also give some counter. And in the meantime, Sridhar, Sindhu madam, Pramod sir, what do you say? Bhavya madam, Pramod sir. Manasa madam, Akila madam, Rashmi madam, Raju sir. Yes, please. So Soumya madam says, sir, if person not mentioned properly, refer of author then led to infringement. Okay, not an infringement when alone with the author name is shared. Okay. Okay, wonderful. Yeah, I just wanted to open up and make you people to discuss and debate and understand about the nitty-gritties of this particular issue of copyrights, because we have our own understanding on copyrights. Many a times it can be right, sometimes it may be wrong. So today what we are going to discuss is, now I'm going to start my session. Okay, in the meantime I have two responses. I'll just read out. Indeed it amount to an infringement. Sridhar sir says indeed it amount to infringement as it is copyrighted. It cannot be replicated and circulated. Wonderful, Sridhar sir, absolutely right. Without the permission of author you cannot circulate or replicate, right? And Mukunda sir says after the said period of time it's not infringement, as commercial gain would be over, it can be made available to public use. Yes, absolutely right. Mukunda sir, I agree with you, provided. Why I agree with you? Because if it is after the lifetime of an author or the period of protection of copyright. Okay, tell me what is the period of protection for copyright? Yesterday I have told. What is the period of protection for copyright? Yes. See, patent provide protection for 20 years, right? What is the period of protection for copyright? Lifetime of an author. Not accurate answer. Even languages department also, ma'am. Yeah, done. The creator, 60 years. Lifetime author plus 60 years. Not 70 years, Bhavya ma'am. It is 60 years. Earlier it was there. Now it is only lifetime of an author plus 60 years. Yes, you are all right. Copyright provide protection for lifetime of an author plus 60 years. Just imagine, sir. Are you referring lifetime of author? If I'm now, I'm just assume 30 years plus another 30 or 40 years I'm going to live, plus 60 years, around 100 years you consider for my literary work of general protection which I have. Do you refer a book or circulate something which is a 100-year-old book? Do we still, what do you say, circulate that book? And will anyone be bothered about it? No one will be bothered. So my only question is, that copyright protection is for lifetime of an author plus 60 years. And this is a time for commercial gain. And anywhere at this point of time, I can make a revenue out of it. And anyone who makes an infringement, I can file a suit against him. But after my lifetime of an author plus 60 years, after that, anyone can use. But even then, there is one more rights called as moral right. What is this moral right? Even after the expiry of the time of the author or the protection of copyright, you should still give two major rights under moral rights. One, it is called as paternity right. Another one, integrity right. I will tell you in the due course of my session. Okay. Very good. Thank you very much for opening up for a debate. I'm really happy for Soumya ma'am, Bhavya ma'am, Mallikarjuna sir, Mukunda sir, and others. Okay. Yes. Let me go ahead further. Tell me quickly what now. Some slides are going to come up. You should not repeat the answers. Whatever you have, you should not repeat the answers. Okay. Before I go to the content, if you have any questions, I will address now itself, because I have discussed a lot of issues and it may be jumbled up in your mind. I will open up. I will remove one by one all your doubts and clarify with the content. it's students. If student borrow a textbook from us and get it photocopied, who should the author sue? Xerox photocopy, Xerox shop owner, or the teacher, or the student? Wonderful, Mukunda sir. Wonderful. This is a case. I have it in my slide. This is a case of Delhi photocopying case, which was decided in the year 2016 by the Supreme Court of India. When I will tell you the case now itself, because I was really enthusiastic when you asked this particular question. 1 second. ಹೇಮಂತ್ ಸರ್ ಎಲ್ಲಿದ್ರೆ ಅಲ್ಲೇ ಕೊಟ್ಬಿಡಿ, ವಿವೇಕ್ ಕೊಟ್ರು ಅಂತ ಹೇಳ್ಬಿಡಿ. ಎಸ್. ಸೊ I'll take up Mukunda sir's question and I'll then go to the content. Okay. The first question, as he's rightly, okay, I'll open up the debate also for this. Okay, no, let me answer it because we have to go to the content. Okay. If the student borrow a textbook from us and get it photocopied, who should the author sue? Whether it is the photocopier or the teacher or the student. Okay, I'll open up the question. I'll tell to everyone, I'm asking everyone, who should the author sue? Come and tell me, student, teacher, or a photocopier? Bega ellaru ononda uttara heli nodona. Fast. Quickly, please. Bhavya ma'am, Soumya ma'am, Srinivasa sir. Mukunda sir, ನಿಮ್ಮ ಮೇಲೆ ಒಂದು ಕೇಸ್ ಆಯ್ತು, ನೀವೇ ಅಂತೆ ಫಸ್ಟ್ ಕೇಸ್ ಹಾಕದ್ ನಿಮ್ಮ ಮೇಲೆ. ಓಕೆ. ಶ್ರೀಧರ್ ಸರ್ ಸೇಸ್ ಟೀಚರ್ ಮತ್ತೆ ಫೋಟೋಕಾಪಿಯರ್ ಇಬ್ರ ಮೇಲೂ ಕೇಸ್ ಹಾಕಿ ಅಂತ. ಶ್ರೀಧರ್ ಸರ್ ಸೇಸ್ ಫೋಟೋಕಾಪಿಯರ್ ಮೇಲೆ. ಭವ್ಯ ಮೇಡಮ್ ತೊಂದ್ರೆನೇ ಬೇಡ ಸರ್, 3 ಜನದ ಮೇಲೆ ಕೇಸ್ ಹಾಕಿ ಅಂತ. ಆಮೇಲೆ ಅಷ್ಟೇ ಅಲ್ವಾ? ಓಕೆ. ರಜನಿ ಮ್ಯಾಮ್, ಐ ಥಿಂಕ್ ಇವಾಗ ನೀವು ಸ್ವಲ್ಪ ಆನ್ಸರ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. ಓಕೆ, ಐ ಫೀಲ್ ಇಟ್ಸ್ ಟೀಚರ್. ಓಕೆ, ಟೀಚರ್ ಮೇಲೆ ಕೇಸ್ ಹಾಕೋಣ. ಓಕೆ. ಮಂಜುಳಾ ಮೇಡಮ್ ಸೇಸ್ ಸರ್ ಟೀಚರ್ ಮೇಲೆ ಹಾಕಿ. ಶ್ರೀದೇವಿ ಮೇಡಮ್ ಸೇಸ್ ಸರ್ ನೋಬಡಿ. ಇದೇನಿದು ಹೊಸ ತರ ಆನ್ಸರು? ಮೇಡಮ್ ಏನೋ ಟ್ರೈ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಯಾರು ನಮ್ಮ ಶ್ರೀದೇವಿ ಮೇಡಮ್, ನೋಡೋಣ ತಾಳಿ, 3 ಜನಕ್ಕೂ ಸೂ ಮಾಡೋದು ಬೇಡ ಅಂತ. ಹರೀಶ್ ಸರ್ ಹೇಳ್ತಾರೆ ಬೋತ್ ಫೋಟೋಕಾಪಿಯರ್ ಅಂಡ್ ದ ಟೀಚರ್. ಶ್ರುತಿ ಮೇಡಮ್ ಸೇಸ್ ಇಟ್ ಇಸ್ ಟೀಚರ್. ಆಯ್ತು, ಎಲ್ಲ ನೀವು ಹೇಳಿರಿ. ಬಿಕಾಸ್ ಟೀಚರ್ ಹ್ಯಾಸ್ ದ ರೈಟ್ ಟು ಯೂಸ್, ಬಟ್ he does not have right to give rights to take photocopy. ಓಹೋ, ಏನ್ ಸಮಯ ಮೇಡಮ್ ನೀವು? Yes, the answer is provided by the Supreme Court of India and not by me. Okay, so that you can rely, because ನಾನು ಇವಾಗ ಒಂದು ಟೋಪಿ ಹಾಕ್ಬಿಡ್ಬೋದು ನಿಮಗೆಲ್ಲ, ಸರ್ ಅಯ್ಯೋ ಹಂಗೆ ಸರ್ ಹಿಂಗೆ ಸರ್ ಅಂತ ಏನೋ ಒಂದು. ಆದ್ರೆ ಲೆಟ್ us be authoritative and say what Supreme Court said. ಓಕೆನಾ? ಓಕೆ, ಇಲ್ಲೇನೋ ಒಂದು ನಮ್ಮ ಪ್ರೊಫೆಸರ್ Rajesh sir says published material is already having copyright with publisher. Okay, so Ariken sir, student will not be aware of the copyright, so they are not liable for punishment. No madam, ನಾವು ಇವಾಗ ಸಿಗ್ನಲ್ ಜಂಪ್ ಮಾಡೋದನ್ನ ಬಗ್ಗೆ, ನಾನು ಸಿಗ್ನಲ್ ಬಗ್ಗೆ ಜಂಪ್ ಮಾಡಬಾರ್ದು ಮಾಡಬೇಕು ಅಂತ ನೀವು ಯಾರಾದ್ರೂ ಪುಸ್ತಕದಲ್ಲಿ ಓದಿದ್ದೀರಾ? ಇಲ್ವಲ್ಲ. ಇಗ್ನರೆನ್ಸ್ ಆಫ್ ಲಾ ಇಸ್ ನೋ ಎಕ್ಸ್ಕ್ಯೂಸ್ ಎಟ್. ಸರ್ ಅಲ್ಲಿ ಮಾಡಬಾರ್ದು ಅಂತ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಸರ್, ಹಾಗಾಗಿ ನಮ್ ಬಿಟ್ಬಿಡಿ ಸರ್ ಅಂತ ಕೇಳಕ್ಕೆ ಬರಲ್ಲ. ಫೋಟೋಕಾಪಿಯರ್ ಅಂಡ್ ಟೀಚರ್, actually they are not using the content and no one is hiding the author. There are changing the name of an author. No sir. Okay, photocopier and student. Okay, ಆಯ್ತು, ಎಲ್ಲ ಫೈನ್ ಸಾಕು. So what did Supreme Court file? Or what was the facts of the case? The facts of the case is, in the Delhi University, there was one Ishwari Xerox in the campus. What did this Ishwari Xerox did? The student used to get it Xerox their materials from this photocopier because of simple reason, purchasing of 800, or because it was university, it has engineering, all other departments. So getting photocopy, madam, uttara kelkoli. ವಿನುತಾ ಮ್ಯಾಮ್, ಎಲ್ಲ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಕೆಲವು ಸತಿ ಕೆಮಿಸ್ಟ್ರಿದು, ಫಿಸಿಕ್ಸ್ದು ಇದೆಲ್ಲ ಪುಸ್ತಕ ಕಾಸ್ಟ್ಲಿ ಇರ್ತದೆ. ಈ ಕಾಸ್ಟ್ಲಿ ಇರೋ ಬುಕ್ ಅನ್ನ ಇವರು ತಗೊಂಡೋಗ್ಬಿಟ್ಟು 1500 ರೂಪಾಯಿ ಇರೋ ಪುಸ್ತಕನ ಕೇವಲ 300 ರೂಪಾಯಿಗೆ 200 ರೂಪಾಯಿಗೆ ಜೆರಾಕ್ಸ್ ಮಾಡಿಸ್ಕೊಂಡ್ ಬಂದ್ಬಿಡ್ತಾ ಇದ್ರು. ಟೀಚರ್ಸ್ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರು? ಟೀಚರ್ಸು ಒಂದ 16 ಪುಸ್ತಕಗಳಿಂದ ಇಂಪಾರ್ಟೆಂಟ್ ಪೋರ್ಷನ್ಸ್ಗಳನ್ನ, ಇಂಪಾರ್ಟೆಂಟ್ ಚಾಪ್ಟರ್ಸ್ಗಳನ್ನ, ಇಂಪಾರ್ಟೆಂಟ್ ಆರ್ಟಿಕಲ್ಸ್ಗಳನ್ನ ಮಾತ್ರ ಜೆರಾಕ್ಸ್ ಮಾಡ್ಕೊಂಡು ಇವ್ರ ಹತ್ರ ಒಂದು ಮೆಟೀರಿಯಲ್, ಏನೋ ರೀಡಿಂಗ್ ಮೆಟೀರಿಯಲ್ ತರ ಜೆರಾಕ್ಸ್ ಮಾಡಿಸ್ಕೊಂಡು ಮಕ್ಕಳಿಗೆಲ್ಲ ಹಂಚೋರು. 50-60 ಕಾಪೀಸ್ ಮಾಡಿ ಮಕ್ಕಳಿಗೆಲ್ಲ ಹಂಚೋರು, ಅಥವಾ ಯಾರಾದ್ರು ಬೇಕು ಅಂದ್ರೆ ಅಲ್ಲಿ ತಗೋಬಹುದಾಗಿತ್ತು. ಇಲ್ಲೇನಾಗೋಯ್ತು? ದಿಸ್ ವಾಸ್ ಅ ಕೇಸ್. ಈ ತರ ಮಾಡ್ತಾ ಇದ್ರು. ಇನ್ ದ ಮೀನ್ ಟೈಮ್ ದ ಆಕ್ಸ್ಫರ್ಡ್ ಯೂನಿವರ್ಸಿಟಿ, ಸರ್ ಇದು ಯಾವ್ದೋ ನಮ್ಮ ಲೋಕಲ್ ಈಸ್ಟರ್ನ್ ಬುಕ್ ಹೌಸು ಅಥವಾ ಪೆಂಗ್ವಿನ್ ಅಥವಾ ಇನ್ನೊಂದು ಯಾರೋ ಲೋಕಲ್ ಅವರಲ್ಲ ಇವರು, ಕೇಂಬ್ರಿಡ್ಜ್ ಯೂನಿವರ್ಸಿಟಿ ಅವರು. ಕೇಂಬ್ರಿಡ್ಜ್ ಯೂನಿವರ್ಸಿಟಿ ಪ್ರೆಸ್, ಆಕ್ಸ್ಫರ್ಡ್ ಯೂನಿವರ್ಸಿಟಿ ಪ್ರೆಸ್ and one more, 3 persons filed a suit in the Supreme Court stating that, sir, this is our copyright. ನನ್ನ ಪುಸ್ತಕಗಳನ್ನ ಇವರು ಜೆರಾಕ್ಸ್ ಕಾಪಿಗಳ ತರ ಮಾಡಿ ನನಗ್ ಬರ್ಬೇಕಾಗಿರೋ ರೆಗ್ಯುಲರ್ ಕೋರ್ಸ್ ಅವರೆಲ್ಲ ತಗೊಂಡ್ ಇಟ್ಕೊಂಡ್ಬಿಡ್ತಾವ್ರೆ. ಕೊಟ್ರ? ಸೊ ಇಟ್ಕೊಂಡ್ಬಿಡ್ತಾ ಇದಾರೆ ಸರ್ ಅಂತ ಹೇಳಿ they filed a suit against him for copyright infringement. ಟೀಚರ್ ಮೇಲ್ ಫೈಲ್ ಮಾಡಲಿಲ್ಲ ಸರ್, ಸ್ಟೂಡೆಂಟ್ ಮೇಲೂ ಫೈಲ್ ಮಾಡಲಿಲ್ಲ. ಆದ್ರೆ ಅವ್ನು ಮಾಡಿದ್ ಯಾರ ಮೇಲೆ? ಫೋಟೋ ಕಾಪಿಯರ್ ಮೇಲೆ. ಏನಂತ ಹೇಳ್ದ? ಈ ತರ ಇವರು ಜೆರಾಕ್ಸ್ ಮಾಡಿ ಮಾರೋದ್ರಿಂದ ಸರ್ ಯಾರು ನನ್ನ ಪುಸ್ತಕ 1,500 ಕೊಟ್ಟು ಯಾರು ತಗೊಳ್ಳಲ್ಲ ಸರ್. 1,500 ಕೊಟ್ಟು ತಗೊಂಡಿದ್ ಪುಸ್ತಕನ ಇವ್ರು ಲೈಬ್ರರಿ ಇಟ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ 3ನ್ನ. ಅದನ್ನೇ ಕಾಪಿ ಮಾಡಿ ಎಲ್ಲಾ ವರ್ಷಕ್ಕೂ ಅದನ್ನೇ ಸರ್ಕ್ಯುಲೇಟ್ ಮಾಡಿದ್ರೆ ನನ್ನ ಪುಸ್ತಕನ ಯಾರು ತಗೊಳ್ತಾರೆ? ನನ್ನ ಪುಸ್ತಕನ ಯಾರು ತಗೊಳ್ತಾ ಇಲ್ಲ. ಜೊತೆಗೆ ಇದರಿಂದ ಏನಾಗ್ತಾ ಇದೆ ನನಗೆ, ನಾನು ಇವಾಗ ಆಥರ್ಗಳಿಗೆ ಪುಸ್ತಕಗಳು ಬರಿಬೇಕು ಅಂತಂದ್ರೆ ಐ ಹ್ಯಾವ್ ಟು ಪೇ ದೆಮ್ in huge number of money. So if I want to pay them and whenever they have to give the huge import to ಚೆನ್ನಾಗಿರೋ ಪುಸ್ತಕ ಬರಿಬೇಕು ಮಾಡಬೇಕು ಅಂತಂದ್ರೆ ನಾವು ತುಂಬಾ ಕಾಸ್ಟ್ಲಿ ಇರ್ತದದು, ನಾವು ಅದಕ್ಕೆ ದುಡ್ಡು ಕೊಡ್ಬೇಕಾಗ್ತದೆ. ಸೊ ಹೌ ಕ್ಯಾನ್ ಐ ಪೇ ದಿಸ್ ಆಥರ್ಸ್? ಅಂಡ್ ಮತ್ತೆ ಅಷ್ಟೇ ಅಲ್ಲದೆ ಒಂದು ಬುಕ್ ನಾನು ಪ್ರಿಂಟ್ ಮಾಡಿ, ಪಬ್ಲಿಷ್ ಮಾಡಿ, ಅಡ್ವರ್ಟೈಸ್ ಮಾಡಿ, ಏನು ಸೆಂಟ್ರಲ್ ಬರುವಂತ ಮಾರ್ಕೆಟಿಂಗು, ಅಡ್ವರ್ಟೈಸಿಂಗು, ಮತ್ತೆ ಬ್ರೋಕರೇಜ್ ಚಾರ್ಜಸ್ಗಳು, GST ಇದೆಲ್ಲ ಕಟ್ಕೊಂಡು ಬಂದಾಗ ನನ್ಗೆ ಎಲ್ಲಿ ಪ್ರಾಫಿಟ್ ಸಿಕ್ಕುತ್ತೆ ಸರ್? ನೀವು ನನ್ನ ಪುಸ್ತಕಗಳನ್ನ ಈ ತರ ಫ್ರೀಯಾಗಿ ಎಲ್ಲಾ ಕಡೆ ಜೆರಾಕ್ಸ್ ಮಾಡ್ಕೊಂಡು ಓಡಾಡ್ತಾ ಇದ್ರೆ, ಐ ಬೀಯಿಂಗ್ ದ ಕ್ರಿಯೇಟರ್, ಅಥವಾ ನಾವು ಇಲ್ಲಿ ಆಥರ್ಗಳಿಗೆ ಎಲ್ಲಿ ದುಡ್ಡು ಕೊಡ್ತೀವಿ? ಆ ತರ ದುಡ್ಡು ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಪುಸ್ತಕ ಬರೆಯಲ್ಲ. ನಮ್ಮೆಲ್ಲಾ ಪುಸ್ತಕಗಳು ನೀವು ಸಾಫ್ಟ್ ಕಾಪಿ ಮಾಡ್ಕೊಂಡು ಹಂಗೆ ಹಂಚ್ಕೊಂಡಿದ್ರೆ ನಾವ್ ಯಾಕೆ ನಿಮ್ಗೆ ಪುಸ್ತಕ ಬರಿಬೇಕು? ಆ ತರ ಆದ್ರೆ ಯಾರು ಪುಸ್ತಕ ಬರೆಯಲ್ಲ. ಪೀಪಲ್ ವಿಲ್ ನಾಟ್ ಕಮ್ ಅಹೆಡ್ ಅಂಡ್ ರೈಟ್ ಆರ್ಟಿಕಲ್ಸ್, ಪೀಪಲ್ ವಿಲ್ ನಾಟ್ ಕಮ್ ಅಹೆಡ್ ಅಂಡ್ ರೈಟ್ ಬುಕ್ಸ್. This will affect hugely ಅಂತ ಹೇಳಿ they filed a case. This was all their arguments. Okay na? Now don't you think sir, ನೀವು ಒಂದೋ ಎರಡೋ ಒಂದಿಷ್ಟು ಕಾಪೀಸ್ ನ ಮಕ್ಕಳಿಗೋಸ್ಕರ ಜೆರಾಕ್ಸ್ ಮಾಡಿ ಒಂದ್ಸತಿ ಕೊಟ್ರೆ ಓಕೆ, that's fine. ಓಕೆ, ಫಾರ್ ದ ಸೇಕ್ ಆಫ್ ಎಜುಕೇಶನ್ ಪರ್ಪಸ್ ಕೊಡ್ತಾ ಇದ್ರ ಸರ್ ಅಂತ. ನೀವು ವರ್ಷಾನುಗಟ್ಲೆ ಅದೇ ಪುಸ್ತಕನ ಜೆರಾಕ್ಸ್ ಮಾಡಿ ಕೊಡ್ತಾ ಬಂದ್ರೆ ನಾವು ಆಸ್ ಅ ಪಬ್ಲಿಷರ್ where should we go? How can we pay money to the authors, especially when it's a digital world ಅಂತ ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತಂದ್ರೆ ಇವಾಗ ಲೈಬ್ರರಿಗಳನ್ನೇ ಸಾಫ್ಟ್ ಕಾಪಿ ಮಾಡ್ಬಿಡ್ತಾ ಇದ್ದಾರೆ. Yes, yes, done. Yes, yes. Thank you, thank you. Host, earlier I did not have an access to unmute my mic. Nevertheless, I got it. See, I'm really very extremely sorry because of this bad internet which I'm facing. And I feel really sorry because on the flow we were all so connected and going, and we lose the track. Nevertheless, let me put up my PPT. Yes. I was telling you that what happened in the Delhi photocopying case. When they filed a case before them, and this was the argument which was proposed, and my question was, how many of them agree for this particular point? Stating that, sir, if the students and faculties Xerox and photocopying it by the photocopier, then I'm losing a huge amount of revenue because no one will purchase my real, purchase the original book, and only one book which is purchased and everyone is just copying it and making Xerox of it, which will lead to a huge amount of losses to me. And how can I encourage? And this leads to discouragement of writing of copyrighted materials. Antalla heli, whatever there are Antalla heli, they had filed a suit. Now, how many of them agree for this particular? How many of them agrees for this argument? Answers, please. Bhavya madam agrees. Srinivasa says agree. Next. Mukunda sir says agree. Nama Ureli. Somya madamu, Vinuta madamu. Yes, agreed. So everyone agree. Publisher point of view, it's agreed. ನಮ್ಮ ಹರೀಶ್ ಸರ್ ಭಾರಿ ಭಾರಿ ಬುದ್ಧಿವಂತರು ಆಯ್ತು. ಅವರೇ ಹೇಳ್ತಾರೆ, ಸರ್ ಪಬ್ಲಿಷರ್ ಪಾಯಿಂಟ್ ಅಲ್ಲಿ ನಾನು ಅಗ್ರಿ ಮಾಡ್ತೀನಿ, ಮತ್ತೆ ಸ್ಟೂಡೆಂಟ್ ಪಾಯಿಂಟ್ ಹೇಳ್ತೀನಿ ಸರ್. ಆಯ್ತು ಸರ್, ನೀವೆಲ್ಲ ಇಷ್ಟೆಲ್ಲ ಅಗ್ರಿ ಆದ್ರಲ್ಲ, ಸರಿ ಯಾರಾದ್ರೂ ಡಿಸ್ಅಗ್ರಿ ಆಗ್ತೀರಾ ಹೇಳಿ. ಡಸ್ ಎನಿವನ್ ಡಿಸ್ಅಗ್ರಿ? ನಮ್ ನಾಗಾರ್ಜುನ್ ಡಿಸ್ಅಗ್ರಿ ಮಾಡ್ತಾರಂತೆ. ಡಸ್ ಎನಿವನ್ ಡಿಸ್ಅಗ್ರಿ? ನಿರ್ಮಲಾ ಮೇಡಮ್ ಅಗ್ರಿ ಮಾಡ್ತಾರೆ. ಶಾರದಾ ಮೇಡಮ್ ಅಗ್ರೀಸ್. ಡಸ್ ಎನಿವನ್ ಡಿಸ್ಅಗ್ರಿ ಸರ್? ನೋಡಿ, ಯಾರು ಡಿಸ್ಅಗ್ರಿ ಮಾಡಲ್ಲ. ಯಾಕೇಳಿ, ನಿಮ್ದು ಕಾಪಿರೈಟ್ಗಳು ಸುಮಾರುಗಳು ಅದೇ ತರ ಸರ್ಕ್ಯುಲೇಟ್ ಆದ್ರೆ ಏನಪ್ಪಾ ಅಂತ ಚಿಂತೆ. ಬಟ್ ದ ಪಾಯಿಂಟ್ ಇಸ್, ಈ ಒಂದು ಕೇಸ್ಗೆ ಡಾಕ್ಟರ್ ಶ್ಯಾಮನಾಥ್ ಬಶೀರ್ ಅಂತ ಹೇಳಿ ಒಬ್ರು IPR ಮೇಲೆ ತುಂಬಾ ರಿಸರ್ಚ್ ಮಾಡಿ ಫೇಮಸ್ ಆಗಿರುವಂತವ್ರು. ಹಿ ವಾಸ್ ಮೇಡ್ as an amicus curiae to decide on this matter also. There the arguments were proposed. ಮಹಾಲಕ್ಷ್ಮಿ ಮೇಡಮ್ ಒಬ್ಬರೇ ಡಿಸ್ಅಗ್ರಿ ಮಾಡೋರು, ಇನ್ ಮಿಕ್ಕಿದವರೆಲ್ಲ ಅಗ್ರಿ ಮಾಡಿಬಿಟ್ರು. ದ ಆರ್ಗ್ಯುಮೆಂಟ್ ವಾಸ್ ದಟ್, ಸರ್, in India, there is a lot of huge population. First of all, there is a huge population. And ಯಾರು ನಮ್ಮ ಹರೀಶ್ ಸರ್ ಒಂದು ಪಾಯಿಂಟ್ ಆಗಲೇ ಕೊಟ್ಬಿಟ್ರು. We have a huge population. When there is a huge population, huge number of students go to the studying. At the same time, are they all equally equipped to have the same capacity of purchasing power? Can everyone, ನೀವು ಹೇಳೋ ನಮ್ಮ ಟೀಚರ್, ನಮ್ಮ ನೀವೆಲ್ಲರೂ ಕ್ಲಾಸಲ್ಲಿ ನೋಡಪ್ಪ ಒಂದು 10 ಆರ್ಟಿಕಲ್ಗಳು, ಒಂದು 10 ಆರ್ಟಿಕಲ್ಗಳು, ಒಂದು 16 ಪುಸ್ತಕಗಳದ್ದು ಆಥರ್ಗಳ ಹೆಸರು, ಅವ್ರದ್ದು ಟೈಟಲ್ ಆಫ್ ದ ಬುಕ್ಸ್ ಹೇಳ್ಬಿಟ್ಟು, ನೋಡಿ ಇದೆಲ್ಲ ತುಂಬಾ ಇಂಪಾರ್ಟೆಂಟ್, ಎಲ್ಲ ಓದ್ಕೊಳ್ಳಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ನೀವು ಹೇಳ್ಬಿಡ್ತೀರಾ. ಬಟ್ ಸ್ಟೂಡೆಂಟ್ಗಳು ಅದನ್ನೆಲ್ಲ ಪರ್ಚೇಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದಾ? ಇಂಜಿನಿಯರಿಂಗು ಅಥವಾ ಮೆಡಿಕಲ್ಲು ಅಥವಾ ಪ್ಯೂರ್ ಸೈನ್ಸಸ್ಗಳಿಗೆ ಹೋದ್ರೆ ದ ಕಾಸ್ಟ್ ಗೋಸ್ ಮೋರ್ ದನ್ 5,000 10,000 ಫಾರ್ ಅ ಬುಕ್ಸ್ ವಿಚ್ ಈಸ್ ವಾಲ್ಯುಮಿನಸ್. ವಾಲ್ಯುಮಿನಸ್ ಇರುವಂತ ಪುಸ್ತಕಗಳನ್ನ ನೀವು 1,000 10,000 20,000 ಕೊಟ್ಟು ಪರ್ಚೇಸ್ ಮಾಡಕ್ಕೆ ಸ್ಟೂಡೆಂಟ್ಗೆ ಆಗುತ್ತಾ? ಸರ್, ನೀವೇನಾದ್ರೂ ಸ್ಟೂಡೆಂಟ್ಗೆ ಇದನ್ನ ಅಕ್ಸೆಸ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ, ನೀವೇನಾದ್ರೂ ಹೌದು ಮಾಡ್ಬಿಟ್ರೆ ಎಲ್ಲಾರು, if you make a Xerox copy of all these things and give it to the students, then the author will die and tell you stop Xerox. ಏನ್ ನಾನು ಸಾರಿ ಹೇಳ್ಬೇಕಾ ಅಥವಾ ನಿಮ್ಮ ಹತ್ರ ಬೈಸ್ಕೋಬೇಕಾ? ನೀವು ಈಗಾಗಲೇ ಸುಮಾರು ಜನ ಬೈದಿರ್ತಾರೆ, ಎಷ್ಟೊತ್ತಿರಿ ಇಂಟರ್ನೆಟ್ ಹೋಗುತ್ತೆ ಅಂತ ನಮ್ಮ ಟೀಚರ್ಗಳು. ಓಕೆ, ಯಾ, ಸಾರಿ, ಏನು ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ದಿಸ್ ಆರ್ ದ ಫ್ಯೂ ಚಾಲೆಂಜಸ್ ವಿಚ್ ವಿ ಅಕರ್. ಸೊ ವಾಟ್ ಐ ರಿಕ್ವೆಸ್ಟ್ ಇಸ್, ನಮ್ಮ ತುಮಕೂರವರು, ಮೈಸೂರವರು, ಮತ್ತೆ ಎಲ್ಲಾ ಬ್ರಾಂಚಸ್ ಆಫ್ ಅದರ್ ಶೇಷಾದ್ರಿಪುರಂ ಗ್ರೂಪ್ ಅವರು, ಡಿಗ್ರಿ ಕಾಲೇಜು, ಯಶವಂತಪುರ, ಯಾರ್ಯಾರು ಎಲ್ಲೆಲ್ಲಿದ್ದೀರಾ, ಎಲ್ಲಾರು ನನಗೊಂದು ಇಮೇಲ್ ಕಳಿಸಿ, ನಾವೇ ಬರ್ತೀವಿ, ಸಪ್ರೇಟ್ ಆಗಿ ಒಂದೊಂದು ಸಪ್ರೇಟ್ ಸೆಷನ್ಸ್ಗಳನ್ನ ತಗೊಳ್ತೀವಿ. ಓಕೆನಾ? ಇದು ಆನ್ಲೈನ್ ಅಷ್ಟು ಕ್ಲಿಯರ್ ಆಗಿ ವರ್ಕೌಟ್ ಆಗ್ತಾ ಇಲ್ಲ ನಮಗೆ. ನೆವರ್ ದ ಲೆಸ್, ಆಸ್ ಐ ವಾಸ್ ಟೆಲಿಂಗ್ ಯು ಆಲ್, ಸಾರಿ, that's all. Today I'm able to do only this particular case study ತಗೊಳಕಾಯ್ತು. ನಿಮ್ ಯಾವ ಕ್ವಶನ್ಗೂ ಉತ್ತರ ಆಗ್ತಾ ಇರಲಿಲ್ಲ. ಬಟ್ ಕ್ವಿಕ್ಲಿ ವಾಟ್ ಐಲ್ ಡೂ ಇಸ್, ನಾನು ಏನೇನು ಇಶ್ಯೂಸ್ ನ ಓಪನ್ ಅಪ್ ಮಾಡಿದ್ದೆ ಅದನ್ನೆಲ್ಲ ಕ್ಲಾರಿಟಿ ಕ್ವಶನ್ಸ್ ಕೊಡ್ತಾ ಬರ್ತೀನಿ. ಕೇಸಲ್ಲಿ ಏನಾಯ್ತು ಅಂತಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ. ಸೊ ಇನ್ ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಡೆಲ್ಲಿ ಫೋಟೋ ಕಾಪಿಂಗ್ ಕೇಸ್, ಇಫ್ ಯು ವುಡ್ ಹ್ಯಾವ್ ಅಗ್ರೀಡ್ that yes sir, this affects the author, this affects the creator, this affects the publisher, they will be under a loss if you do a Xerox. But at the same time, if the student or a teacher, okay, a student has a right to education, if you curtail the books and the books are not available, books is available but it is not affordable. ಸರ್, ಪುಸ್ತಕಗಳಿದೆ, ಅದನ್ನ ಪರ್ಚೇಸ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ ಸರ್. ಮೆಡಿಸಿನ್ಗಳಿದೆ, ಪರ್ಚೇಸ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ ಸರ್. ಹಾಸ್ಪಿಟಲ್ಗಳಿದೆ, ಆದ್ರೆ ಅದನ್ನ ಅಫೋರ್ಡ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ ಸರ್ ಅಂತ ಹೇಳಿದಾಗ, isn't it, it's a responsibility of the government? Isn't it the responsibility of the government to provide education in such circumstances? Isn't it you should provide it for the people? If you are not providing, isn't it your fundamental right under the Constitution, Article 21 and 21A, it is affected? Isn't it violated? If this is your argument, and at the same time, isn't it the teacher's duty also to provide information to the student? Right to information, sir, that is also fundamental right. Right to information. You are not, see, ನಿಮ್ಗೆ ಕರೆಂಟ್ ಇನ್ಫಾರ್ಮೇಶನ್ಗಳು ಸಿಗ್ತಾ ಇಲ್ಲ ಅಥವಾ ರಿಸರ್ಚ್ಗಳ ಬಗ್ಗೆ ಮೆಟೀರಿಯಲ್ ಸಿಗ್ತಾ ಇಲ್ಲ ಅಂತ ಹೋದಾಗ, then how progress will happen? Progress ಹೆಂಗಾಗುತ್ತೆ ಸರ್? So this is another set of argument which was proposed before the court, considering the whole of India. Sir, ಇದೇ ಕೇಸ್ ಏನಾದ್ರೂ ಇವರೇನ ವೆಸ್ಟಲ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ, ಆ ಫೋಟೋ ಕಾಪಿಯರ್ಗೆ ಹ್ಯೂಜ್ ಅಮೌಂಟ್ ಆಫ್ ಪೆನಾಲ್ಟಿ ಹಾಕಿ ಅವನ್ನ ಸಾಯಿಸೇ ಬಿಟ್ಟಿರೋರು. But we are all fortunate to be in a wonderful land called as India, right? In India, Indian constitution has given so much of right to the common people to live. Indian situation ಹೆಂಗಿದೆ ಅಂದ್ರೆ, ಕಾಮನ್ ಪೀಪಲ್ ಉಳ್ಕೊಳಕ್ಕೆ ಅಲ್ಲ. ಇವಾಗಿನ ಬೇರೆ ಪೆಟ್ರೋಲ್ ಪ್ರೈಸ್ ಅದೆಲ್ಲ ಡಿಸ್ಕಷನ್ ಬೇಡಿ, ಅದೆಲ್ಲ ಆಮೇಲೆ ಹೋಗೋಣ. ಸದ್ಯಕ್ಕೆ ಇಷ್ಟಕ್ಕೆ ಮಾತ್ರ ಸೀಮಿತ ಆದ್ರೆ, the constitution is wonderful and it says the rights are there for the people. Then the court, ಅಲ್ಲ, politicians, politics, laws, ಅದು ಬೇರೆ, but the court is there ಅಲ್ವಾ. We all, even if everything goes, we believe in the court, right? So the Supreme Court stated that this does not amount to copyright infringement and it falls within the ambit of section 52 of Copyright Act, which is stated as an exception. In fact, ಈ ಯೂನಿವರ್ಸಿಟಿ ಪ್ರೆಸ್ ಅವರು ನನಗೆ ಇವನು ಇನ್ಫ್ರಿಂಜ್ಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾನೆ ಅಥವಾ ಅವನು ಸ್ಟೂಡೆಂಟ್ ಇನ್ಫ್ರಿಂಜ್ಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಆಗ್ಲಿ, ಟೀಚರ್ ಇನ್ಫ್ರಿಂಜ್ಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಆಗ್ಲಿ ಕೇಸ್ ಹಾಕ್ಲಿಲ್ಲ. ಯಾರು ಚೆನ್ನಾಗಿ ಗೊತ್ತು, ಇಂಡಿಯಾದಲ್ಲಿ ಸ್ಟೂಡೆಂಟ್ಗೆ ಟೀಚರ್ಗೆ ಕೊಡೋಷ್ಟು ಫ್ರೀಡಮ್ ಇನ್ನೊಬ್ರು ಕೊಡಲ್ಲ. ನಮ್ಮ ಮಕ್ಕಳುಗಳು ಏನೇ ಗಲಾಟೆ ಮಾಡಿದ್ರು ನಾವು ಸುಮ್ಮನೆ ಇರ್ಬೇಕಾಗ್ತದೆ, ರೈಟ್? ಸೊ ದಿಸ್ ಇಸ್, ವಿ ನೋ, ದೇ ನೋ ದ ಪಲ್ಸ್. ಅಷ್ಟು ಗೊತ್ತಿಲ್ದಲ್ಲ ಅವ್ರೇನ್ ಕೇಸ್ ಹಾಕಿರ್ಲಿಲ್ಲ. ಬಟ್ ದೇ ಆಸ್ಟ್, ಸರ್ ನಾನೇನು ಅವ್ನ ಮೇಲೆ ಕೇಸ್ ಇನ್ಫ್ರಿಂಜ್ಮೆಂಟ್ ಅಂತ ನಾನು ಹಾಕ್ತಾ ಇಲ್ಲ, ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಇಷ್ಟೇ ಸರ್, ಅವನು ಬುಕ್ ನ ಜೆರಾಕ್ಸ್ ಮಾಡಿ ಇನ್ನೊಂದು ಮಾಡಿ ಕೊಡ್ತಾನಲ್ಲ, ಅದ್ರಲ್ಲಿ ಒಂದಿಷ್ಟು ಅಮೌಂಟ್ ರಾಯಲ್ಟಿನಾದ್ರೂ ಕೊಡ್ಸಿ ಸರ್. ಅಷ್ಟೆಷ್ಟಾರ ಮಾಡಿ, ಅವ್ರು ಎಷ್ಟೆಷ್ಟು ಮಾಡ್ತಾರೆ ಅದಕ್ಕೆ ಲೆಕ್ಕ ಇಟ್ಕೊಳ್ಳಿ, ಅಷ್ಟಕ್ಕೆ ನಮ್ಗೆ ರಾಯಲ್ಟಿನಾದ್ರೂ ಫಿಕ್ಸ್ ಮಾಡಿಸಿ ಕೊಡಿ ಅಂತ ಹೇಳಿ ಬೇರೆ ತರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅನ್ನ ಪ್ರಪೋಸ್ ಮಾಡಿದ್ರು. ಯಾಕಂದ್ರೆ ಇದೆಲ್ಲ ನಡೆಯಲ್ಲ ಅವ್ರಿಗೆ ಅಂತ ಗೊತ್ತಿತ್ತು. ಬಟ್ ಕೋರ್ಟ್ ಸಿಂಪ್ಲಿ ಸ್ಟೇಟೆಡ್, ನೋ, ದಿಸ್ ಅಮೌಂಟ್ ಟು ಆನ್ ಎಕ್ಸೆಪ್ಷನ್ ಅಂಡರ್ ದ ಕಾಪಿರೈಟ್. ಫ್ಯಾಕಲ್ಟೀಸ್ಗಳು, ಟೀಚರ್ಸ್ಗಳು ಏನಾದ್ರು ಒಂದು 100 ಪೇಜ್ ಮೆಟೀರಿಯಲ್ ನ ಮಾಡಿ ಮಕ್ಕಳುಗಳಿಗೆ ಸರ್ಕ್ಯುಲೇಟ್ ಮಾಡಿದ್ರೆ, ಅದು ಫಾರ್ ದ ಪರ್ಪಸ್ ಆಫ್ ಎಜುಕೇಶನ್, ಫಾರ್ ದ ಲಿಮಿಟೆಡ್ ಸರ್ಕ್ಯುಲೇಷನ್. ಹಾಗಂತೇಳಿ ನೀವು ಒಂದು 500 ಕಾಪಿ ಮಾಡಿಬಿಟ್ಟು ಅವಿನ್ಯೂ ರೋಡ್ ಅಲ್ಲಿ ಎಲ್ಲರಿಗೂ ಹಂಚಕ್ಕಾಗಲ್ಲ ಪುಸ್ತಕನ. ಬಟ್ ಇಫ್ ಯು ಮೇಕ್ ಅ ಜೆರಾಕ್ಸ್ ಆಫ್ ದ ಆರ್ಟಿಕಲ್ಸ್ ಆರ್ ಅ ಬುಕ್ಸ್ ಆರ್ ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್ ಫಾರ್ ಲಿಮಿಟೆಡ್ ಸರ್ಕ್ಯುಲೇಷನ್, ಅಂದ್ರೆ ನಿಮ್ಮ ಕ್ಲಾಸ್ ಅಲ್ಲಿ 60 ಜನ ಇರ್ತಾರೆ, ಅವ್ರ ಮಕ್ಕಳಿಗೆ ಅಷ್ಟು ಜನಕ್ಕೆ ಸರ್ಕ್ಯುಲೇಟ್ ಮಾಡಕ್ಕೆ, ಅಥವಾ ನೀವು ಯಾವ್ದೋ ಒಂದು ಟ್ರೈನಿಂಗ್ ಪ್ರೋಗ್ರಾಮ್ ಮಾಡ್ತೀರಾ, ಟ್ರೈನಿಂಗ್ ಪ್ರೋಗ್ರಾಮ್ ಅಲ್ಲಿ ಒಂದು 50 ಜನ 100 ಜನ ಕೂತಿರ್ತಾರೆ. ಆ 100 ಜನಕ್ಕೆ ನೀವು ಸರ್ಕ್ಯುಲೇಟ್ ಮಾಡ್ತೀರಾ, it does not amount to a copyright infringement. So it is called as private circulation, right? So these are all the various exceptions which is available under the copyright. Okay, so this is with respect to a teacher and a student and a photocopying related circumstances. At the same time, few other questions galna ನಾವು ಹಾಕಿದ್ವಿ. ಏನೇನು? There is, okay, I'll tell you, there is 4 major tests in the copyright. 4 ಟೆಸ್ಟ್ ತಿಳ್ಕೊಳ್ಳಿ. ನಾವು ಯಾರಾದ್ರೂ ಕಾಪಿನ ಏನಾದ್ರೂ ಮೆಟೀರಿಯಲ್ ನ ಯೂಸ್ ಮಾಡಬೇಕು ಅಂದ್ರೆ 4 ಮೇಜರ್ ಟೆಸ್ಟ್. 1, purpose. What is the purpose of making such copies? Is it for educational purposes? ಹೌದು ಸರ್, ಎಜುಕೇಶನ್ ಪರ್ಪಸ್ ಗೋಸ್ಕರ ಒಂದು 80 ಕಾಪಿನ ಮಕ್ಕಳು ಮಾಡಿ ಕೊಟ್ವಿ. ಎಕ್ಸೆಪ್ಷನ್. ಟ್ರೈನಿಂಗ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಕೊಡ್ತಾ ಇದೀವಿ, ಪರ್ಪಸ್ ಕೊಟ್ಟಿದೀವಿ, ಎಕ್ಸೆಪ್ಷನ್. ಅದೇ ನೀವೊಂದು 100 ಪುಸ್ತಕ ಮಾಡ್ಬಿಟ್ಟು ನಾನು ಅವಿನಿಯವರಲ್ಲೋ ಅಥವಾ ಸಪ್ನಾ ಬುಕ್ ಹೌಸ್ ಅಲ್ಲೋ ಅದೇ ಕಾಪೀಸ್ನ ಮಾಡಿ ಮಾರ್ತಾ ಇದ್ದೀನಿ ಸರ್ ಅಂತಂದ್ರೆ ಇಟ್ ಇಸ್ ಅನ್ ಇನ್ಫ್ರಿಂಜ್ಮೆಂಟ್. ಸೆಕೆಂಡ್, ಎಫೆಕ್ಟ್. ವಾಟ್ ಇಸ್ ಅ ಎಫೆಕ್ಟ್? ಸರ್, ನೀವು 60 ಕಾಪಿ ಮಾಡಿ ಮಾರೋದ್ರಿಂದ ಈ ಆಥರು ಇಡೀ ಇಂಡಿಯಾದಲ್ಲಿ ಸರ್ಕ್ಯುಲೇಟ್ ಮಾಡ್ತಾ ಇರ್ತಾನಲ್ಲ, ಅವನಿಗೇನು ಎಫೆಕ್ಟ್ ಆಗಲ್ಲ ಸರ್. ಇಟ್ ವಿಲ್ ನಾಟ್ ಎಫೆಕ್ಟ್. ಬಟ್ ದ ಸೇಮ್ ಬುಕ್, you put it in your YouTube, you put it in your Facebook, you put it in your Instagram for any 100 number of copies to be downloaded, it affects his regular course of business. ಅವನಿಗೆ ಜಾಸ್ತಿ ಎಫೆಕ್ಟ್ ಆಗುತ್ತೆ ಸರ್. ಹಾಗಾಗಿ you should not put the work in the Facebook or in the any other circulation. But ನೀವು ಇಮೇಲ್ ಮಾಡಬಹುದು. ಯಾರಿಗೆ? ಇನ್ಫ್ಯಾಕ್ಟ್ ನೀವು ಸುಮಾರು ಇವಾಗ ವೆಸ್ಟರ್ನ್ ಪಬ್ಲಿಷರ್ಗಳದ್ದು ಕೆಲವು ಕೇಸ್ ಸ್ಟಡೀಸ್ಗಳನ್ನ ನೀವು ತಗೊಳ್ಬೇಕು ಅಂತ ಅಲ್ಲಿ ಕೊಟ್ಟಿರ್ತಾರೆ ಕೆಳಗಡೆ ಕಂಡೀಷನ್. ದಿಸ್ ಆರ್ಟಿಕಲ್ ಆರ್ ದಿಸ್ ವರ್ಕ್ ಕೇಸ್ ಸ್ಟಡಿ ಶುಡ್ ಇಸ್ ಅ ಕಾಪಿರೈಟೆಡ್. ದಿಸ್ ಈಸ್ ಬೀನ್ ಗ್ರಾಂಟೆಡ್ ಅ ಲೈಸನ್ ಓನ್ಲಿ ಟು ಮಿಸ್ಟರ್ ವಿವೇಕಾನಂದ್ ಸಾಗರ್. ಹಿ ಶುಡ್ ನಾಟ್ ಫರ್ದರ್ ಸರ್ಕ್ಯುಲೇಟ್, ಹಿ ಶುಡ್ ನಾಟ್ ಫರ್ದರ್ ಗಿವ್ ಇಟ್, ಅಪ್ಲೋಡ್ ಇಟ್ ಎನಿವೇರ್ ಅಂತ ಹೇಳಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಕಂಡೀಷನ್ಸ್ ದೇ ವುಡ್ ಹ್ಯಾವ್ ಆಸ್ಕ್ಡ್. Ekta madam, I'll just take a few more minutes. Sorry, I had few internet issue. ಹಾಗಾಗಿ ನಂದಲ್ಲ ಪ್ರಾಬ್ಲಮ್, ಇಂಟರ್ನೆಟ್ ಪ್ರಾಬ್ಲಮ್. ಹಾಗಾಗಿ ನಿಮ್ದು ಒಂದು 5-6 ನಿಮಿಷ ತಗೊಳ್ತೀನಿ. So now you cannot simply circulate it over email for 100 people, but you can circulate it to 50 students of yours, or 1 or 2 or 10 students or teachers who ask, ಏರಿ ಆ ಒಂದು ಪುಸ್ತಕ ಮೆಟೀರಿಯಲ್ ಇದೆಯಲ್ಲ ನಿಮ್ಮ ಹತ್ರ ಒಂಚೂರು ಇದ್ರೆ ಕೊಡ್ತೀರೇನ್ರಿ ಅಂತಂದ್ರೆ ಅವ್ರಿಗೆ ಬೇಕಂದ್ರೆ ಕೊಡಿ. ಅದೇ ನೀವು ಎಲ್ಲಾರ್ಗು ಸರ್ಕ್ಯುಲೇಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅಥವಾ ಪಬ್ಲಿಕ್ ಓಪನ್ ಮಾಡಿದ್ರೆ it affects his regular course of business. Third, amount ಅಂದ್ರೆ ಏನು? ಸರ್, ನಾನು ಕೇವಲ ಒಂದು 30 ಜನಕ್ಕೆ ಟ್ರೈನಿಂಗ್ 30 ಕಾಪಿ ಅಷ್ಟೇ ಸರ್ ಮಾಡಿಸಿರೋದು, ನಾನೇ ನಂದು 500 ಕಾಪಿನೋ 1000 ಕಾಪಿನೋ ಮಾಡಿಸಿಲ್ಲ. ಸೊ amount, what is the amount which you have made copies? That is also another test. Fourth, ಪರ್ಪಸ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಬರ್ತದೆ, ಕಮರ್ಷಿಯಲ್ ಪರ್ಪಸಸ್ ಅಥವಾ ಎಜುಕೇಶನಲ್ ಪರ್ಪಸಸ್. ಮುಂಚೆ ನಮ್ಮ ಯಾರು ಭವ್ಯ ಮೇಡಮು ಮತ್ತೆ ಬೇರೆಯವರು ಹೇಳಿದ್ರು, ಸರ್ ಪರ್ಪಸ್ ಎಜುಕೇಶನ್ ಪರ್ಪಸ್ ಇದೆ ಸರ್, ಅಥವಾ ಇದು ಬರೀ ಕಮರ್ಷಿಯಲ್, ದೇರ್ ಇಸ್ ನೋ ಕಮರ್ಷಿಯಲ್ ಗೇನ್. ಸರ್, ಇದನ್ನ ಮಾರಿ ನಾನು ದುಡ್ಡು ಮಾಡ್ತಾ ಇಲ್ಲ. ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಅವನು ಜೆರಾಕ್ಸ್ಗೆ ಎಷ್ಟು ಖರ್ಚಾಯ್ತೋ ಅಷ್ಟಕ್ಕೆ ಮಾತ್ರನೇ ದುಡ್ಡು ಕಲೆಕ್ಟ್ ಮಾಡಿದಾನೆ ಹೊರತು ಆ ಪುಸ್ತಕಕ್ಕೆ 600 ರೂಪಾಯಿ ಅಲ್ಲಿ ಮಾರಿದ್ದಕ್ಕೆ ಇವನು 200 ರೂಪಾಯಿ ಜೆರಾಕ್ಸ್ ಪ್ಲಸ್ 10 ಇನ್ನೊಂದು 100 rupees ಫಾರ್ ಇದು ಅಂತ ಹೇಳಿ ಏನು ಎಕ್ಸ್ಟ್ರಾ ತಗೊಳ್ತಾ ಇಲ್ವಲ್ಲ. ಆತರ ಕಮರ್ಷಿಯಲ್ ಗೇನ್ ಏನ್ ನೀವು ಮಾಡ್ತಾ ಇಲ್ವಲ್ಲ, ಅವಾಗ ಇಟ್ ಡಸ್ ನಾಟ್ ಅಮೌಂಟ್ ಅನ್ ಇನ್ಫ್ರಿಂಜ್ಮೆಂಟ್. ದಿಸ್ ಇಸ್ ಅ ವಂಡರ್ಫುಲ್ ಕೇಸ್ ವಿಚ್ ಇಸ್ ಬೀನ್ ಸೆಟ್ ಔಟ್ ಇನ್ ಇಂಡಿಯಾ. ದಟ್ ವಾಸ್ ಅ ಓನ್ಲಿ ಕೇಸ್ ಅಂಡ್ ದಟ್ ಇಸ್ ಅ ಒನ್ ಕೇಸ್ which the court has given ruling for it. But I and you, because many of them agreed for this kind of circumstances, should be careful to respect the copyright. ಇಲ್ಲಿ ನಾನು ನಿಮ್ಗೆಲ್ಲ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಳ್ತಾ ಇರೋದೇನು ಅಂತಂದ್ರೆ, that we should respect the copyright. What do you mean by respecting the copyright? See, we acquiring the intellectual property rights and saying mine is different issue, but respecting others' intellectual property rights is a very important one. We should teach our students that we should respect copyright. You know, ನಮ್ಮೆಲ್ಲಾ ಮೆಟೀರಿಯಲ್ಗಳು, ಹಾಡ್ಗಳಾಗ್ಲಿ, ಫಿಲಮ್ಗಳಾಗ್ಲಿ ಎಲ್ಲದನ್ನು ಈಸಿಯಾಗಿ ಇಂಟರ್ನೆಟ್ಗಳಲ್ಲಿ ನಾವು ಶೇರ್ ಮಾಡ್ಬಿಡ್ತಾ ಇರ್ತೀವಿ. ಬಟ್ we should not share it because it is the creator has a right over it. Okay, so that's regarding the film and recording industry. But I will not talk about that because that itself is a different huge area. But I'll restrict my topic only to this. Okay.
Vivek sir, I would like to request you.
Yeah.
Because of lot of internet issue, we request you to extend by another half hour.
Now.
So that
No. Ekta madam is already there.
No, now it is Brinda madam, I think.
Is it? 1 second, wait.
Ekta madam is for science.
Okay. Oh, maybe she must have got confused. I saw her, what do you say? She has logged into this program, I believe.
No,
I saw.
clarified with Nagarjun sir, no problem. You can continue so that whatever the information more we get from you, more will be enriched.
No. That I agree. Is Brinda there?
Let me check out.
If because I should not, because they have come and, however, I will be there regularly coming and I have told our teachers, oh, Brinda is already there. Yeah. Sir, Brinda idhar hai. So let me not take her time and let her also share her knowledge. I am always there to share. And if you go.
Done. As you suggest. Yeah.
No. If you go and click in the internet, some more videos of mine will come. Nevertheless, it will not be repeated. Okay. So kindly, I would like to thank, I think do I have another class for commerce students? For commercialization.
Tomorrow you have. Tomorrow you have.
Tomorrow I have. So no problem. Little more time I will utilize on copyright and also talk about the other topics which is allotted to me. So thank you very much, all my dear teachers, for providing me an opportunity and kindly patiently hearing. And there was a lot of debate which happened. I really liked that. And thank you very much, sir. And over to Brinda. Brinda, thank you very much for joining. Yeah. Sir, you can introduce Brinda.
Yes.
Good morning, everyone.
Yes. Brinda madam, just a second. Very good afternoon to you, ma'am. On behalf of Seshadipram Group of Institutions and Karnataka Science and Council Technology, Seshadipram IP Cell and North Bangalore Science Forum, we welcome you here, ma'am. So would like to request you to enlighten us on TRL levels of an invention. And as we know here, all the participants are from commerce, management, and language. So keeping in that view, so we request you and we welcome you for this online program. Hope so. Once the pandemic gets over, we can call you to our campus and we'll have more of interactions and more active participants and we'll have. So over to you, ma'am.
Thank you, Professor Das, and thank you, Vivek and Nagarjuna, for this opportunity. And of course, it's a very, very interesting topic for me to discuss with the commerce graduates here.
One second. Santanu sir,
faculties, all our faculties, head of the institutions, principals, professors, head of the institutions, assistant professor, associate professor, faculty. So
okay, I was also. Yeah.
One second, Brinda. Santanu sir, did you give a background introduction, Brinda?
Yes.
Earlier, have you given or this is the first time?
No, earlier I think we have given. Let me check it out.
No problem. No. I'll just introduce in 2 words.
Yeah, please.
Because I take a lot of privilege in introducing Brinda. That's why.
Yeah,
and
please go.
It excites me. First, the reason is because, sir, my dear teachers, as I said, Brinda has a degree in science, biotechnology. She has a degree in law, bachelor degree in law. She also holds a PhD degree in law and science. A wonderful combination today we have. Brinda, she is a practicing advocate. She is a registered patent agent and many more to her roles to play. Brinda has been associated with Karnataka State Council for Science and Technology in filing lot of patents, trademarks, and guiding various universities, institutions in framing intellectual property rights policies. She was also an instrumental in bringing up in Indian Institute of Science the IP cell and its formulation and filing a lot of patents and negotiation, commercializations of various IPs in Indian Institute of Science. And I take a lot of privilege to welcome her and introduce her. She's a wonderful lady. Okay, she has a vast knowledge on this, and I take this opportunity to thank her for joining this particular program, and I welcome her also for this. We have in this particular group, Brinda, today you will be addressing commerce, arts, discipline in this particular management people in this session, and tomorrow once again you will be speaking to the science discipline where you will primarily focus on science aspect to them. Okay, that's how we have framed. So parallel sessions are moving on. Okay.
Okay.
Situation. So we have Venkatesh sir, who is a principal for this, the guest of for this particular program. Venkatesh sir, thank you very much, sir. You're also there for the program. Yes.
Thank you, Vivek. That was really wonderful of you. Okay, so I was not completely aware of the kind of audience. Yes, although I had I did talk to Nagarjuna yesterday, and then he gave me just about who all are going to be the participants. So now it looks like I'm going to be addressing two different groups. Earlier, I thought that it will be the same group, so I will rearrange my slides based on that. So, so what I can do now, because looks like that today's group would not be participating tomorrow, would not be coming to the session. So in that case, I will have to cover the complete commercialization aspects and of course, the TRL levels. So I usually don't enter into the TRL levels directly, but I try to introduce some concepts before we understand what TRL levels are, and then get into the actual subject of TRL levels. Of course, I will try to focus my complete slides to the audience today based on your expertise. So just give me 2 minutes. I will go ahead and upload my presentation.
ಮೇಡಮ್ ಮ್ಯೂಟ್ ಆಗಿದೆ ಪ್ಲೀಸ್ ಬೃಂದಾ ಮೇಡಮ್ ಮ್ಯೂಟ್ ಆಗಿದೆ ಮೇಡಮ್
Yeah, I intentionally put myself on mute so that there's no background disturbance and just trying to upload it. Yeah, one. Something is happening. I'm not able to. Can you see the screen? No, right?
No, ma'am. We are not able to see.
Okay. Is it visible now?
Yes, madam.
Okay, so I can just go to the presentation mode. Sorry, I had to make some changes in the setting. Okay. So topic is slightly different, but of course the content and what I'm going to cover is, primarily on the TRL levels aspect and the various things which you were just introducing. So I'll begin with it. So next 45 minutes, I will try to cover different types of IPRs. Anyway, session is already complete, so all of you are already aware of it, that kind of intellectual property rights that is available to you. So from the business perspective, it makes a lot of sense for you to understand the kind of IP rights which is available, so that that can boost your business in a drastic way, in a substantial manner, because that is very, very important for any business house to see what kind of IPR protection is possible, how you can have a monopoly in the market. Everything lies over there. And the objective of also having the intellectual property right protection is to create a monopoly, to create an advantage over the other industries or the other companies or your competitors. So that should actually be the objective for you to go and seek intellectual property right protection. So from the creation till the development, till the commercialization, that is what one focuses on. So ultimately, from the management perspective, I think what one sees is create invent is, of course, the technical people, people's portfolios. So you have the technical experts sitting there, and they're the ones who actually work towards creating and inventing. But before that, also the role which a business house needs to play, the management needs to play, is whether creating and inventing in the right direction, creating and inventing for the progress of the company is happening in your industry, or is it something people are just creating randomly based on their interest. Now that is the difference between industry R&D and an academic R&D. When it comes to an academic R&D, so it's just the interest of the faculty, interest of the scientists. They're working in a particular domain. They're like, okay, this is of my interest. Let me see how it progresses. Let me see what I can do to the society, or probably their own interest, and they work towards the progressing of science and technology, and start from the basic research. That is the objective of an academic organization. So they're not going to focus basically to ensure that whatever they're creating, whatever products they're coming up with, probably would require, probably there's a need for the market. So it is not on that kind of a need base which they work on. However, when it comes to an industry, it's a totally different thing. So the requirements for the academics and for an industry is completely different, and one needs to focus on the requirements and then build over it. The next aspect is, of course, the protection. As I was trying to tell you, creating the intellectual property is one. How do you go ahead and protect? So your previous session is what focuses on how do you identify which is the right or the appropriate right available to you for the creation in your entity, be it academics, be it an academic organization, be it a company, a large entity, or a small entity. So the focus is in what is it required for you, what kind of protection is needed, and whether protection is needed at all. That is also another strategic decision one needs to take. And I will let you know when I say whether protection is required at all. Okay. But however, when it comes to, say, a startup or an academic organization, the first thing one sees is, okay, you try to build the portfolio so that over a period of time, people would know, the world would know that this is an innovative company. This is a company, or this is an institute, this is an organization which has a lot of innovation, and there's a continuous R&D work happening, and how is that one tries to understand there's a continuity in their innovation or R&D work. One way to see for an academic organization is, of course, their publications, right? The more the publications you have in the peer review journals, you try to rate them, stating that, okay, this is one of the top organizations, or this is an organization which is growing up the ladder based on the kind of work happening in that entity, in that academic organization. But when it comes to a company, so for a startup, for example, one starts looking at the portfolio. Publications is not an objective for a commercial entity, but what is an objective is to see when it is a technology-oriented company, a product-oriented company, what kind of products are they coming up with? Is there any kind of inventive nature? Is there innovation in their products? So that is what one sees. Or is it, a company who's trying to invest in a lot of R&D and trying to see how over a period of time they're trying building over their existing products. So these are something which one needs to focus when it comes to a commercial entity. And then accordingly, one decides what kind of protection you need. So I think it was the previous session has clearly told you have different kind of rights, which is a patent right, which is a design right. You have a trademark, of course, to ensure that you have your trademark identifiers. So for primarily, there are entities where whatever their products or services are, but it is sold because of their trademark, the value they hold to the trademark. So you have several examples like that. If you look at the service industries, it's probably McDonald's you have, or you go to KFC, it is the brand which really matters. So you might have a similar shop just next to McDonald's, or who might be selling cheaper stuff than what is being sold in McDonald's. But however, the attraction to the youth is the trade, the name of the shop, the name of the entity. So you have McDonald's, so you tend to go to McDonald's. So similarly, KFC. Okay. Now, the same entity, I will take an example of KFC. Probably people who are non-vegetarians might go ahead and think that, okay, maybe the chicken which we get in KFC is not the same as we get in another entity. Why? Because the recipe which these people go ahead and use it for coating the chicken is something different, which is not available outside in other shops, or probably it might be slightly, different from what is available in the regular shops. So that is where KFC holds an advantage. Now, this recipe is something which the KFC has maintained it as a trade secret. So that's a business advantage. If KFC had gone ahead and patented it, okay, the entire recipe of coating their chicken, gone ahead and patented it, maybe, I think you understand, the life of a patent is only for 20 years. So what would have happened? So the minute the completion of 20 years is over, it gets into public domain. When I say public domain, it means that anybody would be able to go ahead and use this recipe to coat their own dishes, to coat their own chicken. So that is the difference. But however, KFC has decided that they would not go ahead and file for a patent. This is their business decision, where they clearly stated they would not go and file for a patent, but they would retain it as a trade secret. So for them to read, so that their business advantage is much longer than the rights given under the patent law. So which is 20 years here, but however, their business advantage of retaining that recipe goes beyond that 20 years. So other than their own employees, probably some of them, nobody else is actually aware of what exact recipe goes into coating their chicken. So that is how one decides what is beneficial to your entity. Okay, whether you need a protection or you don't need protection, all depends on what you want to do with your technology. Another example I would give you here is, say we have some kind of a mechanical product. Okay, so you have come up with some interesting pen which has multiple features, so many features that maybe no pen in the market has. I'm just taking a hypothetical example here. So now what happens to this pen? You might think, okay, we'll go and file for a patent because you have interesting features which is not available in the market. So probably a pen with a quick, fan or something like that. It's just an hypothetical example, okay? So now this pen, are you able to see the screen, the presentation, or has it gone? Calls is disturbing me. Are you all able to see the presentation? Yeah, I think you can all see this now, right? I'm sorry for this intervention. Professor Das, I think it is visible, right?
Yes, madam. Yes.
Okay, thank you. So, sorry, there was there was a call, so I thought the screen just disappeared. All right. So I was trying to give you an example of a pen. Now here, I cannot maintain this invention pertaining to a pen as a trade secret. Why can't I maintain it as a trade secret? The minute this comes into the market, what is going to happen? People would go ahead and reverse engineer it, right? It is easy for you to just look at it and come up with, reverse engineer it and come up with a similar product in the market. So now, in order to avoid that, is what we do is try to go ahead and protect it under the patent law. So the minute you protect it under the patent law, you have a right over it for 20 years, right? Now, because you have a right over it for 20 years, nobody will be able to reverse engineer and come up with the same product in the market. They cannot do that because they would be infringing upon your patent rights. So that is how one tries to decide. If people can actually go ahead and reverse engineer your invention, your products, or your technology, then it is always advisable that you seek some kind of a protection. So patent for inventions, okay, if yours is an innovative company, then of course that is the best thing which we can do. Copyright, I think all of you are aware that for any kind of literary work or the artistic work, and cinematographic work, you try to go ahead and seek protection under the copyright. I'm sure Vivek has already covered various concepts on that, but I'm just trying to give you an example at how you determine what is beneficial to your entity. So that's how you go ahead and protect. I also always give another example of seeking protection here. What is it? An interesting thing I always tell people is the fish medicine, which is given for asthmatic patients in Hyderabad. So I'm sure people have read this in the in the newspapers or seen it in the news, that there is a specific medicine given. Now nobody knows what actually goes into this medicine. Till date nobody knows except the people who are giving that medicine and their family members probably. Now, why is that? The minute people know, and I think if you've also seen, the medicine is put into that fish and directly put into your mouth. It is not even given into your hand. And one of the reasons why they don't give it into your hand is probably because the minute it is into your hand, it is not necessary that you'd swallow it. Rather, somebody with a scientific mind might be very curious to understand what goes into it. So you just go to the lab, do the characterization, okay, and try to see what exactly is gone into this medicine. So that way, you actually try to understand what is there and maybe come up with another business model and set up a similar shop to go ahead and give this kind of a fish medicine. So here, in order to protect that kind of a misuse, or in order to stop the competition, so the best thing what these people decided is put that medicine and then ensure that it is directly put into your mouth. One of the reasons. So that is the reason why till date nobody else in the market actually knows what goes into it, or nobody else in the market is giving you a similar medicine other than that coming from that family. So that is one other way of thinking what is right for your entity and what is that you do to your creation, to your invention, to have a better advantage over others. The other aspect is, of course, the tech transfer, commercialization, and the management. I'll just get into the details of that. So cycle of operations generally, I'm just trying to focus here on a patent, but I think the others does not require this kind of complicated cycle of operations. For example, trademark. So once you have, it's a brand image. So once you go ahead and come up with an interesting trademark, you just go protect it and start renewing it to ensure that, till your business is in existence, you tend to have a right over it. But however, for patents, or even sometimes even for designs, the story is a little complicated. So you have to create something. Even for industrial design, you create something. And I think all of you should understand that, I'm sure you'll have a session on industrial design, but that also requires a lot of strategy for you to understand when and how you're trying to protect it. And please do understand, for design registration, protection is compulsory, because without protection, you would not be able to, go ahead and publish it, or even put it up in public domain. So that is very, very important for one to have a design protection. But however, for patents, of course, what matters here is the timing of you seeking that kind of a protection. So the timing, and basically when are you trying to introduce into the market, and what time you're trying to protect it. That really matters for for patents or for inventions. So you create, and then after creating, you have to validate to check whether your invention is in the right mode, the right track. Then you get into the prototyping, and once you get into the prototyping, that is where you test to see whether it's really working. Just try to see the cycle of operations is very important for you to understand the TRL levels. Okay, so that is the reason why I'm actually trying to take you to this slide. Then that is when you go ahead and disclose to your team members to see whether there's appropriate protection is possible. Then you collaborate for various reasons. Prosecution of the patent happens, okay, grant, and then licensing or the commercialization, whatever you think is best for your entity. Okay, so invent, patent, technology transfer, commercialization. These are the various aspects which are very, very important for any patent related things, or any technology for that matter. Now, IP management, as I kept telling you from the first slide, if tapped correctly, intellectual property or the intellectual property rights can become one of the revenue generating sources for an entity. Now, what kind of creation, what kind of intellectual property rights, it is actually the technologies and the management who needs to take a call on it at the appropriate time. Timing really, really plays a very, very important role when it comes to intellectual property rights. If you delay, you lose. You lose the race, and at the same time, you're not supposed to introduce it much ahead the requirement of the market. Even there you lose. So the exact timing is what matters here. So please do keep that in mind. So the three important aspects for the IP management is the technical. So when I say technical, it includes conception and development. Then you have legal, includes appropriate protection, as I've been telling you, and business, which includes commercialization and the marketing strategies. Now, these are the most important requirements for any entity to sustain the competition and have an advantage over others. Okay, this is where your IP management becomes important. So creation can be at the different levels. So we have divided into 4 broad phases. So the idea or the conception phase, the development and design phase, the prototype and the pre-production phase, and the marketing and commercialization phase. Okay, so the idea or the conception phase, I think all of you are aware where it stands, what it is. Even at the idea or the conception phase, it is important for you to understand when it comes to a company to see whether the idea, what you're trying to come up with, would help or would benefit the company or the benefit the entity. Unlike the academic organization, as I gave you an example. But however, so all these kind of discussions will have to happen at the initial stage itself. Just don't get into, either you create a market for yourself. Okay, so that is one way that I'm sure all of you would agree to, that you'd be looking at. Or, I always give an example of Apple products, computers were there in place, when Apple came into the market. But then the strategy was so good that they started, now people start looking at Apple products at a different level. You have an Apple, you have a laptop from Apple. You also have a laptop from HP, which is much cheaper. You have a laptop from Dell, but still there are some additional features which they try to introduce into the product that people look at it as at a different level. So that is how he created a market for himself, and he's got a very niche market. Of course, he's trying to come up with different strategies now to see how he can supply to various masses. But for him, it was always an elite mass, and that is what he was targeting at, and he was quite successful. I mean, rather very successful in doing that. The development and design phase is the next one. So once you've conceived an idea, once you know that, okay, this is really going to work and this technology has a lot of potential, then you start developing over it and then start designing it. And one also needs to understand the number of years or the number of months you require for the development and design phase. That also matters for you to place the product in the market. Okay, so people think way ahead. Intel, for instance, they think way ahead. They're probably you would not even have thought about the ideas, what is going to come up in the market 5 years down the line. That is how they try to focus. And because they would require that kind of timelines for them to conceive, develop, and prototype and put the beta version in the market. So for them to really think much ahead of all of us is what these companies sustain to this extent and surviving and always have an advantage over others. Intel didn't have I think all of you would agree that Intel does not have that kind of a competition, but at least, but now you have other companies like AMD trying to come into picture for processors. There is a competition which is created, but still, the way they think is way ahead. Microsoft, when they try to introduce various products, they come up with fantastic features, trying to see how easy is it for people to operate on their systems, operate on their products, So these are added advantage or the special features which they keep trying to introduce and trying to attract customers so that, people go ahead and depend on that. And I think almost all of us are so dependent on the Microsoft products that we don't feel like using any other products, and we always think, okay, operating system, I think we feel, okay, Windows is the best. There are a lot of hardcore technologies for them, for them they start using different operating systems, but still when it comes to Office, I think all of us are so used to Microsoft Office features that it is very, very difficult for us to just migrate from the Microsoft Office to another product or product provided by another company. So that is how they have tried to create a market to ensure that you are dependent on their products to this extent. And please remember that every product Microsoft comes up with, every product Intel comes out with is always well protected and well thought of. Okay, so appropriate protection is sought. So whether it's Microsoft, Intel, IBM, they have lot of patents to their portfolio, and of course when it comes to their software per se, they have a lot of copyrights added to their portfolio, and that is how they always have an advantage over the existing other companies. The prototype and pre-production phase also is another stage, and the marketing and commercialization phase comes at the end. So once everything is in order and you feel that, okay, it's all working, is when your the marketing and commercialization strategy needs to be put out. Now, points to consider for everyone is involving the right people at the genesis of IP can save a lot of heart attack later on. This is definitely something which I have also been seeing personally when I interact with various startups. The way they fail for various reasons. One of them is, of course, these wrong decisions pertaining to the investment in the technologies or investment in the IP protection. Please do understand that IP protection definitely requires a lot of funds. So that also is something which you need to keep in mind. And because of the competition you have in the world, so you will have to ensure that it is all appropriately protected. So researchers desire to publish in a culture more biased to science rather than business. So that is something which we need to understand. And that is where entity has a lot of policies in place. And people who have, I think people who have already worked in the company and then come back to academic organization, you would be aware the kind of documents you sign. And I'm not sure how many of you have actually gone through your employment agreement. And I'm not very sure whether your college also has an employment agreement in place. And the kind of paperwork which a company asks you to sign is definitely different from the kind of paperwork an academic organization asks you to sign. So when it comes to company, you have the first and the foremost employment agreement, under which you have the IP clauses very strongly added. You have the confidential information, particularly if these people are into R&D, then all the more tough contracts which they will have to sign. So they are not allowed to go ahead and publish like the way academic organizations are. But here, as I told you in the beginning itself, it's totally different. When it comes to companies, the first focus is, if you look at that they are supposed to disclose it to the concerned department of your, of the company. And that company, that department would be usually the legal department or the IP department. And they are the ones who will scrutinize, evaluate it, and see whether it should be protected. And then if not protected, then the next step is whether it should be published, in which journal it should be published, or should it just be a white paper. So these are the various strategic decisions which the IP department would actually consider when a researcher is involved. Okay, so they cannot just go ahead and publish without the knowledge of the IP department or the legal department or the management department of an entity. So, it is must that it has to go through that route. But however, when it comes to an academic organization, it's totally different. You have the freedom. Your objective is to go ahead and publish as many papers as possible. Please do it. But of course, currently there are a lot of academic organizations, R&D based organizations who are focusing on patent protection. The reason is it's a mandate that you generate your own revenue. And one of the revenue generating sources is, of course, patents. Okay, so I think I'm lost on this again. Sorry. Okay, so that and that is definitely a revenue source for a lot of academic organizations. We say so. The top academic organizations, be it Indian Institute of Technology, be it Indian Institute of Science, be it NITs or any engineering colleges. So they're all focusing on how to build their portfolio and see how they can generate revenue, so that over a period of time they're self-sustainable and don't have to depend on government funding for R&D purposes. So that is another mandate which has already been given by the government of India, so that they succeed over it. And it will take some time for them to come into that innovation culture and also the innovation culture. I think there's always been there, but trying to focus on what the industry requires. So if you do a lot of basic research, which is also a requirement for an academic organization, you might not sustain in the market. You might not be able to sell your inventions, right? But however, if part of your research is also focusing on what the industry requires, then of course you'll be able to sell your work to that industry. So that is where every industry will have its own policies. It will have its publication policies. It will have its intellectual property policy, and it really is very important for one to have an intellectual property policy to understand who you are supposed to approach when you have an invention. What happens when you have a creation? What happens when you have a design? What happens when you have a copyrightable work? Now, this is you will have to have some kind of guidelines, some kind of policy put forth very clearly in an entity. It may be a company or it may be an academic organization. Doesn't matter which entity it is, but every entity should actually have an IP policy, should have a publication policy. That is something which will guide you through to ensure that you successfully place your inventions or products in the market, or successfully license your technology or commercialize your technology. And in the absence of a policy, it is very difficult for you to streamline the whole process. So because each one of you will be talking in a different language, and you'll not be understanding what exactly needs to be done out of it. So once this entire process is streamlined, then it'll be a smooth flow, and and your success rate of putting the technology in the market is much higher. So I think currently in India, almost all the organizations are coming up with their own policies, which is a very, very good move. And I think it is also The NAC also is insisting that academic organizations come up with their own policies. And this is a move from the government so that once they start forcing upon you, you try to understand the benefits of it, at least over a period of time. May not be immediately, but the next few years is what the focus is on. And then you all start working towards it. If at least somebody knows that we have an IP policy that that we have to refer to in case of an issue. And this IP policy should cover from the conception to all that I just told you in the previous slide. It should have all the phases: conception, protection, commercialization. It has to cover all these phases. At least, substantially is, I would not say, but elaborately is something it should have. It should actually cover all the instances. But however, if not as elaborate as possible, at least, some kind of an overall guideline stating that this is what needs to be done. Trust me, it plays a very, very important role. Another important aspect one needs to remember in any organization, whether it is your company or whether it's an academic organization, training. Okay, training people makes on the intellectual property rights available to you, on the makes it is really important. One example from the management perspective is, how can one use the trademark of your entity? To what extent you're permitted to use the trademark? To what extent you're allowed to enter into contracts, business contracts with your other entities, and and what kind of an IP clause actually needs to go in? What is the company's IP policy? And when it comes to the academic organization, how is that you're trying to place your technology in the market? To what extent they can use it? These are some things which every individual coming into the entity, probably in your induction program, this has to be introduced so that you're made aware of the entire IP strategy. How one needs to consider, how is that you can use, to what extent you can use the name of the company or the various trademarks of your company. In case you come up with any interesting concepts, how is that you need to protect, what is that you need to do, how is that you're trying to negotiate with the entities. When I'm trying to actually negotiate with various companies, interestingly, I deal with I come from the legal background, of course, with the science background too. But when I interact with companies, it is interesting to note that how different people at different stages come to me for negotiating a single contract. Okay, so I'll have the IP expert coming into picture to see what is beneficial to the company when they're funding, say, for example, when they're funding their research work to an entity. Then I have the business people coming into the picture, trying to understand to what extent they can invest, whether it is really worth investing. And, investment is not only pertaining to the funding of any research work, but also pertaining to how later on, they will have to support this academic organization or support the patent protection. It's a business team which will come into picture and see to what extent they can negotiate. And of course, you have the legal team coming into picture to understand the various other consequences of the terms which they introduced. So if you see, you have these three different departments coming and negotiating one single contract. Then, this will give you an example as how important it is for different teams to come together to negotiate. And of course, other than these three, you have the technical team anyway negotiating. Okay, if it's a technical project related contract, then you have the technical team coming into picture anyway. So they're the one who will decide the scope of work. They're the one who will decide how it has to be what work needs to be done from an academic organization and what work needs to be done from the company who's funding. So you have these different teams collaborating and then trying to negotiate a contract. Whether the money is 10 lakhs or 10 crores, you always have this kind of team coming in from the company side. But when it comes to the academic organization, you don't have this level of negotiations or this level of collaboration amongst the various people. But one is, of course, lack of resources and lack of understanding. But I would say lack of understanding is actually coming down, because with the kind of awareness happening, The lot of entities were trying to rework on their appropriate team to negotiate on various contracts or the business dealings or various other aspects which is going to benefit the entity. Protection, I think by now you would have understood that protection and commercialization are definitely two different areas. And the question is whether they're interlinked. Of course, it is interlinked, as I was been telling you in the beginning, because identifying and managing IP becomes very, very crucial for to ensure that your success rate is very high. And when and how you intend to do is, as I told you, timings also really matter. Timing is very, very important when it comes to IP protection and commercialization of it. So legal management, that's what it says. The most important aspect is timely protection of the invention, as it is a crux and most essential aspect before commercializing the invention. So timely protection and timely introducing the product into the market. Now, another important thing, which is relevant for the management folks or experts or is trying to understand over a period of time to what extent you would want to seek this kind of protection. Of course, your IP department is also important. And how is that you're going to keep that, continue to invest in that portfolio, continue to invest in that technology. One needs to really differentiate, trying to say inventions with high value and high enforceability. From the management perspective, these are some of the points which you need to consider. So when the inventions have high value and high enforceability, then IP protection is the first choice. When I'm talking about IP protection here, of course, I'm trying to directly relate it to patents. As I told you, it's the most important right available to you for any technology-oriented companies. Okay, so when you know that inventions have high value and high enforceability, then patents should be the first choice. When inventions with high value and low enforceability, that is when trade secret should be your first choice. Okay, so you decide when you need to have protected as a patent, under patent, and when you need to maintain it as a trade secret. One quick example here I will give you is any kind of a process used to synthesize something. Now the product, of course, as an end product, it might be difficult for somebody to understand what is the process gone into that particular development of that particular product, synthesizing of a product. But once the process is in the market, slight tweaking here and there can actually yield to the similar product or with better features, right? So that is the reason why one tries to understand whether you need to go ahead and seek kind of a patent protection of this process, which nobody actually would know other than your own employees, or should we just go ahead and file for a patent and allow others to go and modify over that invention. Now that is something which you need to decide based on the kind of invention you come up with and the kind of value it has. Now, invention with low market value and high enforceability, these kind of inventions may also be considered for patenting. This is just to help the company to, in a just-in-case scenario. And there are a lot of aspects which we consider here: freedom to operate, block competition. So these are some concepts which you have to keep in mind before going and seeking protection with inventions with low market value. Inventions with low value and low enforceability. So these are the inventions which the the company decides to publish. So either in-house publication or any kind of journal publications is what basically they think. So this is how usually inventions are differentiated and protection is sought for. When I talk about technology transfer, it basically covers, I think I have another 10 minutes. Yeah. When I talk about technology transfer, it has a different meaning when it comes to academic organizations. So since academic organizations are not involved in production or not involved in introducing the product by themselves, so what they do is they seek help from companies who can go ahead and manufacture for them and then introduce the product. So what we basically do when it comes to academic organization is So we go ahead and transfer the technology to them, asking the companies to commercialize it, to put it up in the market. Okay, so that's where we introduce the technology transfer concept here. And unlike the companies, where the companies would pick up their own inventions, manufacture it based on the requirements and sell it. But the universities don't get into that. And when they do this technology transfer, there will be various other aspects which one considers. So which stage your invention is. Okay, so the transactions or the dealing of technology transfer always is based on where your invention stays, where your invention stands, whether it is at the initial idea stage, or whether you've already validated, you've come up with your invention, validated, you've prototyped, you've tested in the required environment, and whether it's ready to be launched. So these are various things which one considers, when you get into the technology transfer. And even for the company, these are the various stages one actually looks into before introducing the product into the market. Okay, so that is where your TRL levels also will come into picture. So generally speaking, technology transfer is a process of transferring scientific findings from one organization to another. So when I say another, here we are focusing on the companies for the purpose of further development and commercialization of the invention. So from the company's perspective, who are not very keen on investing a lot in R&D, so what they do is they scout to see whether any academic organizations are already working in the products of their like. So, and in the process, if they find that some of the academic organizations are definitely, have a patent or, file for a patent in their domain, you actually go to them, negotiate, because you don't have to invest on the R&D, but what you need to invest on further development, because you need to understand the TRL levels. If it's a ready to pick up product, of course, even that, you save even on that money. So you only have to work towards the commercialization. So the marketing is where you'll have to invest in and then go ahead and launch the product. Okay. So the value of a product also is based on the TRL levels. Now, what is this TRL levels I'm talking about? It's the technology readiness level. Okay. And the cycle which I showed you prior also, tries to tell you the different technology readiness level of an invention. So the process typically involves identifying new technologies, protecting technologies through patents and copyrights or design, and then forming a development and commercialization strategy. So marketing, such as marketing, licensing, or creating new startups in case you feel that there is no company who's ready to invest further. Then the creating new startups. So it is very interesting to know that a lot of startups from an academic organizations which are being created. One of the reasons is because your TRL levels are low. So these are the startups who can bridge the gap. They can go ahead, pick up your invention at the low TRL levels, and then ensure that they increase the TRL levels. And once they increase the TRL levels, automatically you will have the bigger companies who would be interested in picking up the product or taking over the company itself, the startup company, which is also your objective, right? So these TRL and these startup companies also get a lot of funding from the government entities precisely for this reason, so that they help improve the technology, grow up the ladder. So that is the objective as well. So that, startups are actually becoming a very, very interesting startups from the academic organization primarily, becoming a very, very interesting way of increasing the TRL levels and ensuring that the companies, just take over that. So I think all of you are already, because all of you are already into the management thing, I don't want to get into the details of this, but I'll give you a quick gist of how it happens, some of the terms which you all have to keep in mind. So as I said, commercialization strategy differs completely from, large and small firms, universities, and individuals, as it can be used for various purposes. So maybe the internal exploitation for companies, technology transfer for academic organization, and for companies, the reason is probably for preventing competition or enhance the patent portfolio filing so that your partnership is enhanced, profit sharing aspect comes into it. Another important aspect is assignment licensing, or you want to give it pro bono as your choice, or joint ventures. This is also a very, very interesting thing. So you probably cross license. When it comes to companies, you probably cross license. When it comes to startups, maybe if you don't have any funds, or if you think assignment of your your inventions to a larger company would add more value to your company, then that is another thing. And even for an academic organization. So the difference between assignment and licensing is I will tell you in the next 2 minutes. Before that, companies also use patents as bargaining chips. There is no doubt about it. Okay, some of the companies also use it as a tool of extortion. So it all depends on what you want out of these patents. Open innovation is a very, very interesting concept, particularly in the copyright domain. Is one, and Tesla is known for its open innovation. So what it means that it doesn't seek any kind of protection, it just puts it up in public domain. There are a lot of advantages and disadvantages. One needs to understand the interesting strategy Tesla has actually come up with to make, and the guts it has to keep its inventions make its inventions or put it up in open domain, or call it as an open innovation. The reason is they have really, a lot of companies who invest so much into some of their very, very important technologies, and they would have thought at least 5 or 10 years ahead of any other company, or, and then invested. So when the minute they go ahead and make it open innovation, if there is a company looking at it to see how you can strategize the other company's open innovation, probably this company would also require equal investment, or would require in equal time the other company, or probably a little lesser time the other company is actually put in, okay, to come up with that interesting concepts and make it open innovation. So, and by the time this new company thinks of reverse engineering or thinks of coming up with similar inventions, the primary innovator company would have already gone much, much ahead than the other company who's trying to copy. So that is something which you strategize so well, and then have the guts to make an invention open. Not all inventions can be made open innovation. Please keep that in mind. Some of the companies, and Tesla is one of the best examples. I think you can try to understand their, when you have time, try to just understand the technology portfolio and how they have, they have actually made it an open innovation. I think in the interest of time, what I'll do is I will directly go into the, I think what I'll do, I'll directly go into the analysis of IP for any industrial relevance and commercial potential, how market evaluation is actually considered. So one is, does invention offer a better and inexpensive way of accomplishing something? Okay, these are some of the points which one needs to keep in mind. This is general basic concepts which one needs actually to keep in mind before you're trying to introduce any product. And it is for any entity, it is not restricted only to a company. So are there competing technologies available in the market? If so, how much better is the invention? And one important aspect which I always highlight, what will be the potential payoff for a company that makes an investment in the development of the invention? Okay, so that is something which one needs to look into, because I see a lot of companies, particularly the startups, investing, thinking that, okay, they can go ahead and come up with an interesting invention, or pick up a basic invention and start developing on it. But then over a period of time, they'll have this cash crunch and, have to shelve the project itself. So please keep that in mind when you're trying to invest in some of the products. Okay, let me move on to the TRL levels and try to make you understand how one determines. So as I told you, it is a technology readiness level, and it is used to measure the maturity of a particular technology. Okay, so it is basically a metric with once again, I think I just skipped that slide. Yeah. So it's basically a metric with 9 technology readiness levels. Okay, and it starts from TRL 1 to TRL 9. So TRL 9 talks about commercial readiness. So it's the highest degree of application, which means your product is ready. No further investment is required from a company from the technology perspective. Okay, and your bargaining power also goes very high if your TRL numbers are higher. TRL 1 is at the basic stage, at the ideation stage. So, okay, so I've just listed out the various TRL levels here. So TRL 1 is the basic principles observed. So it is the ideation stage. TRL 2, technology concept formulated. TRL 3, experimental proof of concept. TRL 6 is technology demonstrated in relevant environment. TRL 8, system complete and qualified. TRL 9, actual system proven in operational environment. Now, this TRL level concept was something which was brought up by NASA, and almost, I think, every industry uses this TRL levels to made modifications based on their requirements for various technologies. Academic organizations also, this becomes very, very important. Particularly when you're trying to negotiate. How is it important? When you're TRL level 1, when your inventions are below TRL 3, then when you're trying to negotiate with a company, obviously you will not get that kind of returns the way if it would have been at the TRL 9. Why? Because the company has to go ahead and invest further in increasing your technology to levels to TRL 9. Okay, only when it goes to TRL 9, as I told you, it's a product, market ready product. So the minute you're from an academic organization, the TRL levels is at 9, which means your bargaining power is very, very high. You can negotiate and then ensure that you get a better deal compared to your inventions at the lower TRL levels. So one also needs to understand the various concepts like licensing, assignment, etc., etc. So when we are talking about licensing of a technology, which means you still be the owner of that invention, however, you go ahead and give certain rights to make, rights to use, rights to manufacture, rights to sell to an entity so that they can go ahead and commercialize your invention. So this is from the academic perspective. When it comes to cross licensing, there are companies. Say as a company A, I have few inventions A, B, C, and company B has inventions D, E, F. So it is important for company A and company D to collaborate so that their inventions are merged, and then without any hindrances, they go ahead and utilize their inventions, right? Unless you don't have some kind of a permission, you cannot use other inventions. So that is very important for you to keep in mind. So the minute I cross-license, company A cross-licenses it to B, and B licenses its technologies to A. So that way you have the freedom to go and use each other's inventions without any problems and integrate it into your existing product. Okay, so cross-licensing becomes very important. Now, when I talk about assignment basically means selling your rights, as opposed to licensing it. So it's the difference is between renting your house to selling your house. Assignment concept means selling your IP rights. So you just go ahead and sell your rights to another entity, whether you're from a company, you think, okay, this portfolio is something which might not be of interest to me. Let me just go ahead and sell this portfolio to another entity who's working on it. Or maybe you are not interested in that one particular vertical, you shelve that one particular vertical of your company. Okay, and then that portfolio belonging to that particular vertical, you go ahead and sell all the rights you have to another entity so that they can go ahead and pick it up. Okay, even when you're selling it, it all depends on what kind of protection you have. So as I told you, your negotiations will actually improve and you'll have a better stand when your TRL levels are high, your portfolio is very good, and also the kind of protection you have for the technologies you have. Okay, so all these really matters when you're trying to negotiate. So these are something which the other people will, discuss with you over a period of time. And I will not get into the details of this. So I would like to conclude with this by stating that part of a good IP strategy is to have IP savvy people at brainstorming meetings. It really, really helps, whether well-trained staff or an IP strategist. Okay, so this way, whether it's any entity, whether it's a commercial entity or a non-commercial entity like an academic organization, it really benefits to have the appropriate people, for the appropriate discussions, and also help you gain better advantage compared to organizations not having such IP savvy people. So with this, thank you very much. I think I really tried to rush through, and I am beyond that, it's because 1 hour is too less for me to cover various concepts in detail. So I've just brushed through various concepts, and at any point of time you have any kind of questions, you can always write to me, or you can always write to KCST and they will forward it to me. I'll be glad to help you out. And of course, day in and day out, I've been interacting with various entities, helping various entities in negotiating their IP portfolio or protecting their IP portfolio under various levels. So probably from creating the IP policy to helping them commercialize, to helping them protect their IP at the appropriate stages. So I think I've been doing this for the past 12, 13 years. And I'm really proud that, I've been able to help a lot of organizations in streamlining their IP portfolios, and also helping them have their own IP policy so that their entire process is well streamlined. Thank you very much for your kind attention. And I think if any one of you have any questions, I'm open to that.
We would like to request the participants and esteemed faculties and delegates to kindly ask questions if you have in the chat box. Yeah, ma'am, there is a question. So if you can stop sharing the screen, madam, so that it becomes.
Yeah, I'm doing that. Correct.
Yes.
Okay. That's an interesting question. How MSMEs can be benefited from IPR? So I don't know if I've just missed from the, when I'm actually talking about NTPs, I didn't focus on the startups or an SME or an MSME or a large entity. It was basically for every organization at different levels. Now, there are a lot of MSMEs who are only involved in manufacturing the existing products, or or probably just licensing it out from somebody. Now, where does it really work? I'll give you one, an example here. When I'm actually I think Vivek did tell you that I have also been associated with Indian Institute of Science. And there's some case studies which we're actually working on to see how MSME can really utilize their or benefit from IPR. Unfortunately, not many MSMEs do understand the importance of having their IP portfolio because they focus only on the manufacturing side. But what we are trying to do is trying to collaborate with MSMEs and trying to make them understand the importance. Now, these MSMEs are not, I'm not talking about all, but some of them are not ready to invest in the R&D. Okay, so for them, that is one of the they think resources which is not of very beneficial. Okay, so they don't go ahead and invest. So what we are trying to do there is trying to see if Indian Institute of Science can go and invest for them, bring in projects from the government of India, because there's always a lot of support from the government of India. Bring in the projects, combine with MSME to see what are their requirements, okay, and see how we can actually help in bridging the gap which they have. So as I told you, they can always improve in their manufacturing sector, in their manufacturing process. Okay, come up with their interesting concepts and create an advantage for them over the existing, manufacturing sectors or products which they launch. So the minute they're tied up with an R&D organizations like IITs and IICs, we bring in them, try to give them the new concepts. We tell them that you don't have to invest in your R&D. So we go ahead and scout to see what kind of products they have, what are the improvements they need, what are the flaws they have, okay, and then try to help them by seeking funds from the government, or to some extent they're also ready to invest, but of course to not a large amount, but to the extent they can, and bridge that gap, take in this and tell them that you would be one of the owners here of this patent, or we tell that, okay, organization, we are ready to give you a license, an exclusive license, so that you gain benefit out of it. And over a period of time, their manufacturing process is also better, improves, the quality of the product increases, they don't have to depend on somebody else's product, and they will definitely have an advantage over a period of time. And this model is actually working, and there are a lot of MSMEs who are coming forward to talk to IICs and IITs, so that they can go ahead and have a better portfolio, go and have a better process in place, go and have a better product in place. Okay, and they have slowly tried to understand having an importance of some kind of an IP protection for their own process. They have a lot of jugaads also in their systems, but unfortunately they don't realize that it can create a lot of value, add a lot of value. But yes, over a period of time for their manufacturing sectors, these are something which is adding a lot of value. Maybe it will take another 3 or 4 years for the MSMEs to really come out with their own portfolios, but it is in process. And trust me, it is really, really helping them create an identification of their own. The other question is, other than publishing papers and books, what are the other benefits teachers get from IPR? Other than publishing papers and books, benefits, of course, the minute you go and publish books itself, you get a copyright over it. So when you get a copyright over it and your book is interesting, you automatically try to generate revenue by getting some kind of a license fee from the publishing house. So that is one thing which you should always consider. Books also has a lot of value, a lot of IP. And I think already all of you know that the rights over any, literary work is life of the author plus 70 years. So which means you can actually seek revenue from the publishing house for so long, for so that many years. It will also go to the legal hires. Other than that, when you say teachers, it also depends on which domain you belong to. Okay, so if you are belonging to the domain of science, of course, you are the one who can inculcate that habit of innovation. I don't think it is also, I think I should take back my word saying related to science. But as a teacher, it is your responsibility to inculcate that kind of an innovation into the students, so that they try to understand what can actually be brought out to the market. How innovation can better the society, whether it is ideas, various business ideas you come up with, or various innovative ideas pertaining to the science and technology you come up with. I think teachers are the one who can play a very, very important role. For personal benefit, I think it is only the research articles or books which you publish which can when it comes to the non-science and engineering background, it is, you can only rely on that. But for science and engineering background, of course, you yourself can come up with interesting inventions and go ahead and generate revenue out of it. Need for changes in regulations to suit the industry. I'm not sure what exactly you're referring to, Dr. Prasad. I think I would want you to please let me know what exactly your question is. Are you trying to ask me whether is there a need for changing in regulations to suit an industry? If that is your question, then I think the government has already understood the importance of innovation, importance of having the Make in India concept itself is trying to focus on that. Of course, that is pertaining to the manufacturing, but trying to work with a lot of organizations, I see there is a drastic change in the rules, regulations, and policies from the government of India, from the respective state governments, to go ahead and help every sector. It is not only on academic, it is not only on startups, but whether it is MSME, whether it is startup or a larger entity. I think there is continuous process in changing the regulations to encourage the industries to get into the innovation side, to go ahead and seek appropriate IP protection. Even if you look at the patent law, there has been amendment which talks about stating that, encouraging the startups to go and file more and more patents. And how is that they've done? They've reduced their patent office fees. That is one of the way they're looking at it. So I think it is already in process. A lot of things happening out there, both by the central and state government. And I think, and I'm quite happy with the way the changes are taking place. And of course, I would not say that it suits everybody's requirements, because we need to understand how this, going to help the industries at various verticals of various sizes. I hope I have answered your question on that. Okay. So I don't see any further questions. If there's anything else, you can either type in or you can unmute yourself and please ask me.
Yes, ma'am. So we thank you, ma'am, for your elaborate descriptions and helping us to understand what about the TRL levels of an invention. And in fact, I could see that tomorrow also you are going to speak on institutional IP policy and technologies transfer, if I'm not wrong. So wish you a very stay safe and healthy, and wish you soon that you will be back to our campus and help us, our teachers, holding them to understand with more case studies, so that it will be better for us to understand, because it is a wide and very broad area. And we understand that within an hour, it won't be easy for any speaker or anyone to make understand, or even the learners to know that. But anyway, I think you have done the best possible way to justify that. We wholeheartedly thank you, madam, and see you soon tomorrow again with more of IP policies and technologies. Thank you, madam. Thank you.
Thank you very much.
Thank you, madam.
Have a safe and good day. Bye.
Thank you. And I request all our delegates, that same link will be back again at sharp 2 o'clock. Request everyone to put P before you exit, so that it becomes easy for us to. I request everyone to just in the chat box put P, and you can leave for the lunch, and then again we'll be back at sharp 2 o'clock. Murthy. खाना है अभी खाना I request all the participants to kindly enter P and go for lunch and back at 2 o'clock.
Sir, can you able to hear?
Yes, sir, I can.
Okay, okay, fine, sir, fine. Yeah. So in another 2 minutes, sir, I'll be
Yeah, so we'll start at by 2:05.
2:05. Yes, fine. Yes.
Sir,
Sir, if participants are ready, then we can go ahead, sir.
I request for the post-lunch session, all the esteemed delegates, that we had IP audit and commercialization by Dr. Sanjeev Kumar, NRDC, but due to certain medical emergency, he couldn't take. So our Nagarjun sir is ready to take the session for both. So no, this session some other day we'll check out with. So we hope we pray God he stays safe and healthy, and we are here, Nagarjun sir, as always.
Yeah.
Vivek sir and Nagarjun sir to take us through the journey of IP.
Thanks.
So we have introduced him. So instead of further delay, I request sir to take the session.
Yes, sir.
Yes.
Yeah. So small clarification. Have you informed the science streams to kindly join to this particular
I have
session,
informed
right?
them.
Okay.
And here also, once the science faculty has joined, I tell you, madam and sir, for science stream, we request that 3 to 4 session, again, it will be splitted. Same Google Meet you have to use only for this session, 2 to 3, it will be combined. Over to you,
Okay.
sir.
Yeah. Thank you, sir. Thank you very much. Sir, can you see my screen?
Yes, you have to go for slideshow and done. Yes.
Now we can see, right? Okay,
Yes.
fine, sir. Dear students and faculties, okay, so in this particular session we will deal with this industrial designs. Okay, so this is one of the important IP topic where if you are not able, or there is a little difficulty regarding you to file patents, okay, but you can strategize your idea by doing some kind of industrial designs registrations on your name, and if it is you can able to do some kind of entrepreneurship also in this criteria. See how that we will deal in this particular topic. Okay, so if you see this particular slide, okay, so whenever we say an industrial design, okay, so especially with the engineers, if you say any design, there will be a scale coming in his mind with the and meters. Okay, for civil engineer a tape will come in mind. Okay, so because these are all the standard areas. Okay, so if you say the word that is designs, some kind of based upon their education background, it will go. Okay, so basically this is for especially for engineers. Okay, so even in the same kind, for example, if you say something to design for a woman. Okay, so what she will thought for her jewelry and her earrings, etc., etc., depend upon their kind of taste. Okay, so but we should know that in the topics of intellectual property rights, okay, so this industrial designs we have a little divert based upon the exact definition of these designs, okay, as per the textbooks that they have given. Okay, and regarding its measurements, mathematical calculations. Okay, so it's especially with the functional aspects. Okay, so everything is a little different if you go in deep in this particular topic. Okay, so just observe those slides. If you see here, we have mobile phones, okay, electric switches, we have iPods, we have fan, and here we have cycles also. Okay, so just have a look at the evolution of cycles here. Like the first cycle which was giving us a dowry in earlier olden days, maybe my father had got a cycle like this. Okay, so as a dowry. Now people don't accept until you need to provide a bike or some kind of a car. Okay, so that's the current scenario now. Okay, however, many people are there that they won't take any dowry also. Okay, so just observe the figures here. There are, have you observed, there are changes over the existing one, the new coming one, and here we have different cycles also. Okay, so just have a look at the different kind one. If you see here, this is the olden days kitchen and the modern days kitchen, how it looks. Okay, if the current situation, if the kitchen is not furnished, okay, with the furniture and all, people would not accept at all. Okay, so they want high advanced things to be there in their kitchens and homes, obviously. Okay, it's quite common nature. So to do this, or what is the background for this particular changes? Okay, so of course an IP is a tool for that. In that case also, this industrial designs plays an important role. Here also we have few other designs like plates, eating plates. Okay, so some kind of a bottles. Okay, so I mean some I'm just talking about the shape. Okay, no description on the contents because I don't know that. And if you see here some kind of rangoli over there, and this is very much known to all of us, right? I mean, because we have been used this kind of articles in our day-to-day lives, and still some of the PE teachers which you had in this particular session, if they have, they can have a very good experience over this particular articles, okay, which is specially used in sports, and even we used in sports. But why this slide has been mentioned here? So how and what is the importance, that also will go in deep, right? So in my above slides, have you seen a lot of pictures, right? So the first thing is, my question is, what is the advancement that you seen on the slides? What is the innovation, or do you find any changes? Yes or no, that's all. Sir, I couldn't able to see the chart box. Okay, so could somebody help me with that? What is the changes that you seen on the earlier my slides, where we have switches, fans, everything? Does all the equipment, I mean the articles, okay, are with the same structure, or which appears the same, or they have a little difference with the one to one another?
From Sharmila madam, it's shape and size.
Yes, okay, good. Shape and size, one thing. Any other answer, sir?
No, only one answer.
Okay, fine, sir. Yes, madam, exactly, you said correct. The shape and size is different. The appearance of the articles for one-to-one is complete. I mean, I say not completely, but it is different. Okay, where you can also judge with your own soul eye, right? So now come to the exact definition according to the Intellectual Property Act. Okay, so that says this design, according to the 2000 Act, we have for patents, designs, trademarks, everything, we have certain acts and rules. Okay, so in that terms, this designs is 2000. According to that, a design is given to any shape, configuration, pattern, ornamentation, composition of lines, colors to any article, either in the form of 2D or 3D, which can be manufactured either manual or mechanical or chemical, which is visually aesthetically appeal to the eye. Okay, so which means whatever the product that you come up, or you want to design, okay, or you see, it has a shape, configuration, it should have a pattern, or maybe it should have a pattern or any ornamentation or color combinations which can be produced any kind of system like manual, mechanical, automobile. Okay, so now which can be judged only by your eye. Okay, so and in this design you should note that, see, this is the protection is given only for the visual appearance of the article, not on the functional aspect. Okay, but if you take the history or whatever the previous background of any particular article, okay, so if you want to come up with some kind of innovation, there should be some kind of necessity. Either it should look very creative, okay, very attractive to us, and second thing is, even if you want to do some kind of designs, there should be some functional aspects. Means there is a necessity for some functional aspects, then only the idea of designs, everything has evolved and it should come up. For example, if you take, if you take a bottle, okay, like plastic bottle, if you take, you just observe the knob, okay. Does the knob is with the with the, I mean, the knob has some kind of little patches over there, patches or some kind of reference will be given, so that if you open that particular knob, it will come easily, okay. Suppose if the complete knob has the cap with very neat structure, then it is very difficult to lose that particular cap, right? Okay, so there the the structures or some kind of references that they have given on the cap is a functional aspect, okay. So but however, the protection for the design is only given for the appearance of the article, that's all, okay. Now come to the different shape, size of article based upon the definition. That we said that a design can given based upon the shape of the article. If you see a lot of shapes here, okay, ornamentation for ornaments, okay. So like color patterns, like automobiles, if you take how many colors, cars, vehicles you have, okay, and with the ornamentation, okay, and especially with the textile materials, what kind of engravings that you have, okay, with a variety of shapes. So everything can have their own kind of significance. And especially these designs are categorized in two major things, that is, one is two-dimensional and another is the three-dimensional. Two-dimensional in the sense that is the textile materials or fabrics or the sheet t-shirts or some kind of cloth materials that you wear, and other things come with the normal 3D dimensional structures, that is cars, chairs, okay, everything, okay. So this is a major thing. And in the designs we have one more group called making a registration for set of goods which having a similar kind of structure, similar kind of character, similar kind of common design, okay. So for example, best thing is, if you see here, the kitchen items like tea cup, saucer, okay, knives, everything. So just the dimension is vary, that's all, rest of the characters remain same. So for these kind of articles, what generally we will do a set registration, okay. So just by taking registration for one article, it's sufficient for the various dimensions. For example, if you see here, design number 323, okay, under was foodstuffs, okay, fine. So this is pressure cooker with container and lid set for household articles. See, this is a design registered product. Observe that your cooker is design protected, the shape of the cooker is design protected, right? Okay, so this is filed by TTK Prestige Limited. Prestige company has taken the registration for this particular cooker. So like that, many articles you use in your day-to-day lives, okay. So all have most of all they have some kind of IP register over there. Now this industrial design, okay, so I was mentioning that you can make some kind of, you can make the file, taking a design registration is a little bit easy compared to patents, I said that, okay. Like how, if you want to make a patent filing, okay, obviously the cost is more, and another thing is you need to put some more R&D effort in that. Of course, in the design, product design also you need to put more effort, but however, the cost, if you consider for patent filing, obviously the government fees about 25,000, okay. So minimum government fees for patent filing is 25,000, and for designs you can file just within 5,000 rupees, okay. So that's a simple comparison. Now come to the importance of this designs in the market, okay, or in industry. So any product, for example, if you take, if I say mobile, okay, which mobile you buy? Which is your first preference to buy any mobile phone? So some answers, please. Obviously, I believe in the chat box, that is the first and foremost selection of your a mobile is that iPhone. Okay, why? Because of the security reasons, because of its trademark, okay, so because of its size, shape, and finally, if you want to choose a particular mobile, okay, then finally you comes with a color combination. Okay, so people may have a kind of vastu interest, they will go with some kind of mobile colors, okay. So like that, the color combinations plays an important role in selection of the product, okay. That's where this industrial designs plays an important role. So, and this designs, it's make a product very attractive and appealing, right? Okay, so that's why there is a large demand in a particular type of vehicles or articles or automobiles. For example, if you take an automobile, a simple bike itself. Okay, so first if you choose bike, obviously you go with the Bullet. Okay, so now come to KTM next, then obviously some other designs of a Pulsar, all those things. So in the Harley Davidson or in the Bullet, okay, so after selection of your bike, then you will go with the price. Okay, I mean then you go with the color of the bike. Okay, so color in the sense generally matte green. Okay, and now the common color is black. So for black we have some kind of a separate cost. For matte green color we have some kind of separate cost. Okay, so that's why even the color attracts more, and that it makes the product at a higher selling rate. Okay, so it targets specific market segments. Okay, in the sense, like for example, if you take the watch itself, see the professionals like us will wear the chain watches. Obviously the other the kids generally have these kind of kid watches, okay, which looks toy kind of watches. And with the teenagers, they will always have a digital watches which can which having LED light, other things and all. Okay, so now we have the Bluetooth watches, digital watches, and people are adopting that also. They're going. Okay, so this designs plays a very important significant market role in the different age groups also. Okay, and to create a new market, it's obviously okay. So if you fed up with the black color, you then go with the buy other interesting color like silver. Okay, so silver color, black, whatever it may be, your way of this thing. Okay, yeah, and obviously it creates a good branding image, and it creates the strengthening of brands. Okay, so obviously just if you look at the trademark of the design case of Apple, it is very unique compared to other mobile phones, right? Okay, so obviously there is a brand creation over this particular designs. The designs monopoly is for 10 years. Okay, so it can be extendable for 5 more years. This is also one of the difference between the patents. That is, patents is given for you for 20 years, but this designs given for you 10 years, and it can be extendable for 5 more years. So there are some criteria for this designs registration. Okay, so however, in the similar way of patents, okay, like new, novel, and industrial applicable, these designs also should be matched the same criteria, where it should have new, original, and it should have an individual character. In the sense, new in the sense, first of all, you are looking at that particular product for the first time. Okay, so which is the product not available earlier itself. Okay, so it was the first kind of thing, that is the design is coming into the market. Okay, so it should be original, like it should produced by an original author. Okay, and it should have very significant findings, and also it should have an individual character, like that it should have some kind of attraction over the particular product. Okay, so suppose example, if you just see this kettle here. Okay, so we have one kind of kettle. Have you observed this kettle in our homes? No, 90% of homes doesn't have this kind of kettle, because the shape, everything that we use the kettle is different. But this maybe you can see in this 5-star hotels. Okay, so where it feels it gives some kind of greatness to them, so that they can serve in this particular thing. Okay, so this is how it should have some kind of individual identification of the product. And always a design should not be disclosed to the public. So once you register your design, then you can publish it. Okay, so otherwise the designs that you come up with, it should not be disclosed to the public earlier before the registration. Now, it should be significantly distinguishable from known designs. For example, if you see that particular glasses over there, we have 2 glasses in this particular thing. Of course, both are made from same material. What is the major difference that you found? Okay, can you find any difference? Yes or no? With the 2 glasses over there, have you find any difference? Sir, any answers? No answers. Okay, fine. Fine, I believe no answers. I couldn't able to see the chat box, so that I'll just continue. Okay, fine. So if you see this particular thing, I'm in the session. Can anyone say, just unmute and say? Okay, fine. Fine, sir, fine. Okay, so if you see this particular two glasses, which are say made from the both same material, but you can easily distinguishable the glasses, right? Because one with the conical shape and one with the circular shape. Okay, so and both are very unique in their size, structure, shape, everything. Okay, so like that, whatever the designs that you come up, okay, in any field, okay, so in any field, it should be identified easily. Right. It should not contain any scandalous or obscenity matter. Okay. So, and it should apply to an article. Obviously, there is no contradictory to the public order and morality. Okay. So here in the sense, for example, if you take this particular wash basin in the bathrooms. Okay. So if you engrave some kind of design of a god, will it be acceptable? Okay, it cannot be acceptable because we generally don't pray god in bathrooms. Okay, so I mean we cannot keep such kind of photos or whatever this kind of designs cannot be accepted. Okay, so if you design this kind of things, it cannot be accepted for design registration. Okay, so and now come to this the exclusions from the design. See, we have, I told in the beginning that any design is given only for the appearance of the article. Okay, so not on the function, not on the design, not on the functional aspect. So here the principle of construction of a design product, okay, cannot be considered for design registration. Mere mechanical devices, I'll show that. Buildings and structures, okay, cannot be considered. Trademarks, okay, as per the definition of a trademark act, all trademarks should go for trademarks. There is no design registration for that. So however, the artistic work like copyright work cannot go for design registration. Okay, so here these are some of the functional designs, which means that they are mere mechanical devices in the sense. Okay, so you can see this particular articles in your day-to-day life. Okay, the wrench, angular basket, knife, everything has been they become more popular and they are very common to us now. Okay, so however, all these have their own kind of functional aspects. Okay, if you made some kind of improvement over there or some kind of product changes in this particular area, then it can go for design registration. Okay, now if you take the tires itself, see you can see different kind of tires. The MRF have some kind of a pattern on that. The which tires others, C8 has some kind of patterns over there. Earlier we used to have this the tires with a tube. Okay, so you need to blow that. Now punctureless tires are there. Now there is no hair at all. Okay, so now the advanced tires are coming. Okay, so it doesn't get the puncture itself, and the wheel, the size, design is completely different. Okay, so that's the innovation that's coming here. Okay, now for any product, okay, it should have a significant market in the global. Okay, so it should have some kind of product development every year. In every aspect. For example, if you see in the particular slides, we have a lot of interesting things here. That is, if you see that particular bottle, okay, so which was used for some great occasions, I don't know. Okay, so here, if you take, they made a rubber cork based upon the wood. Okay, this is Channapatna toys. Okay, you know very well about Channapatna toys, which has got J registration. Okay, so recently we have visited Channapatna toys for some kind of interview. Okay, so which was, we are filming a GI toys for Government of India's documentary. Okay, so there we just observed. Okay, so the company, they are come up with innovative products there in the wood. Okay, so now the metal caps has been replaced this with the particular wood caps. Maybe some kind of bio connection are there, but however, see how the packaging was done. Okay, it was very interesting. Okay, so that's why we just clicked some snaps over there. And if you see this chair particularly, especially designed for the first rank student, first rank Raju. Okay, so where he can sit there, he can study any number of books. Okay, so maybe above this advancement will come. Okay, where he can do everything at a single point of at present. Okay, so now come to the chairs. The banana look like chair. Okay, so in similar way they had making some kind of openers. See, earlier we have metal openers for 5 rupees. Now just they have the same thing has been implanted in a wooden stick, and they do some kind of product variation, and now they are selling this particular wooden openers. See how innovative are this? Okay, a simple changes. Okay, a simple change can make you to buy some products, right? Okay, so this is the importance of the design. These are some of the local innovations that I have found. We have a magnetic pen which can stand alone. You don't need of any supportive box for that. Okay, so it will be there. And here if you see for the bottle especially, which is very interesting about this particular bottle. Okay, so I said in the beginning that the projections given on the cap is a functional aspect. Okay, otherwise the slippage of bottle will happen. You just observe the stripes given on the particular bottle, and maybe the stripes are common in many of bottles. Okay, so for your information. Fine. So here if you see, we have two open lids, that is one with the cap and another with the half bottle itself. See how innovative is this product, right? Okay, so in many occasions, generally the problem if you go a long trip, okay, so maybe sometimes the petrol get empty. Okay, so now at that point of time, what we will do, we'll go with search for some kind of bottle, petrol bunk, everything. Even if you find a petrol bunk, there is a shortage of bottle. Okay, then you need to, you need to take a, water bottle. You need to drink all the water. Then you go with the petrol bunk, fill the petrol, and you need to fill the tank. Okay, so this how if you use this particular this bottle especially. Okay, so even sometimes if you pour into the tank, okay, there will be a slippage of the petrol. Okay, so this can be avoided with this particular bottle, where it can be used as a funnel also. So here we have multiple functionality for this particular thing, but however the protection is only given for the shape itself. That's all. Now, there are many more innovations taking place in the area of foodstuffs. Okay, the day-to-day activities. Even if you see your day-to-day activity, your table itself, your study table itself, the laptop, chair, mobile, okay, the pen, everything has their own kind of appearance. Okay, and most of them are IP protected. Okay, so with the examples you can see in the slides. Right now, come to this particular teacup. Okay, so which is looks, a very brilliant idea this is. Okay, just he made a hole on the handle. Okay, so now this is a registered design, and probably you can find this particular teacup, everything. It will be, I have not found this particular thing right now. Maybe it will become shortly. A simple changes made over for the bowl. Okay, so we used to have a ring holders, but here they just replaced with the plastic, and they made registration for this particular article. Okay, and especially with the foodstuffs, the shape of the food. Okay, so for example, if you take the biscuits, best example, see each biscuits have their own kind of shapes. Okay, so maybe you have observed the crack jog, okay, the good day, everything has some kind of pattern over the biscuit, right? So everything is protected. So these are some of the innovations that we do, and we have protected at KCST. Okay, so and come to the Design Act. Okay, so in the designs we have total 11 chapters, 4 schedules and 48 sections. Obviously the first schedule deals with the fees, the second schedule deals with the forms. Total we have 23 forms. However, in the earlier session with the patents, Madam Ekta was mentioning that the forms 1, 2, 5, 3 need to be filled for the patents. In similar way, we have design forms also, where till 23 we have. The main form that you fill is form 1. Okay, now we have, all the different offices functions on the designs also, but however all the applicants will be directed to Kolkata. Kolkata is the head office for the design registration. Okay, so any individual can be filed. You alone can file the design registration either by offline or online. Okay, so through attorney or any legal representative, you can go for the design registration. Now if you want to file any design application, there should be the background. You should know the background. Okay, so we have classification for the designs, which means all the products are categorized under a simple category. Okay, so totally we have 32 classifications for the design registration, where if you want to file anything, you need to identify under which category that your product is enrolled or it is entitled. Then based upon the class, you can file the design registration. In similar way, how the patent classification, that is international patent classification, okay, so IPC. So here also you have design classifications. That design classification we called as Locarno classification. Okay. Now, so someone need to help with me. Okay. So if you see this 7 articles here, number 1 can go for any design protection, yes or no? Number 1.
No.
Number 1, no. Okay. So what may be the reason, sir?
Everyone
What may be
putting
the
no.
Everyone putting no. Okay, fine then. Okay, probably you say that. Okay, number 1 is a copyright protected one because this is a painting. If you, as it is, if you see that, right? Now another thing is, since it's also a national interest, in the terms of national interest, it cannot go for design registration. Okay, so anything which relates to national interest and the copyright work and the trademark work cannot go for design registration. Okay, now come to the second point. Can the second point go for design registration? Number 2, which look like a painting for me. I believe for you also it look like a painting. Can it go for design registration? Yes or no?
No, it's coming as no in the chat box.
Okay, fine. See, as it is, if you see that particular thing, here we have a small clause. That is, as it is, if you see this is a painting. Obviously, according to the Designs Act, a painting cannot go for design registration. So you may go for copyright protection. But however, here we have one interesting thing that, okay, if you make, okay, so if you make the same thing more than 50 copies, okay, and you do the business, okay, or it can be imprinted on any t-shirt, okay, the butterfly can be imprinted, okay, and it can be sold more than 50 copies, then it become eligible for design protection. Okay, because design can given for this in the textile area. Okay, so however, the painting can be drawn on a particular cloth. Okay, if it is able to sell more than 50 copies, which is unique, okay, then it can go for design registration. Okay, however, the painting as it is up to your wish whether you need to go for copyright or you make business out of it and go for design protection. Okay, yes. Number 3, if you take a teapot, can it go for protection? Yes or no? Any yes or no, sir?
Yes.
Yes. Okay, but here we have a one class, because as it is, if you take a teapot, I said in the beginning the functional designs, that is, which have very common to us, very well known to us, and which is become absolute to us, that kind of articles cannot go for design registration. In this particular case, the teapot, if you take, we know this kind of teapot shape from the beginning, like in the olden days, from the beginning, olden days, we know this particular shape, right? But the engraving that you make on the particular this article makes with the difference with the existing one, and hence this can be eligible for design registration. Okay, so in similar way, if you take 4 and 5, okay, so 4 and 5, can anyone under 4 and 5 category, which one go for registration, 4 or 5, or maybe both? What is your answers?
5.
5. Okay, so hopefully everyone got the idea, I believe. Okay, number 4 you take, this is very absolute to us because it's known to very well, and the design protection for this particular shape is observed. Okay, it is exhausted. Okay, just a second, sir. Yes sir, yes sir. Amadi sir, 4 o'clock bani sir. 3 o'clock, 3 o'clock, yes. 3 to 4, 3 to 4, 3 to 4, yes. So the session naditida 3 to 4 bani sir. Yeah, sorry for that. Okay, yeah, now as it is, if you take number 5 can go for registration because of its some kind of improvement over the existing one. Number 6 you take, can it go for design protection? It's a biscuit. I mean, you already know that. Can it go for design protection? Have you find any common a similar kind of biscuit in the market? Just yes or no. For 6, yes or no. Any answer, sir?
Yes.
Yeah, okay. So fine. Number 6 you take, okay, it can go for design registration. How in the sense, okay, so this is a very new Britannia biscuit that they had got this particular design. Okay, if you count the number of pores, it is less, and there are some kind of engraving, some kind of design pattern over the in the corners. Okay, so that's how it makes eligible for the design protection. It is published now. Okay, so this is the new Britannia biscuits. Now come to the 7. Can it go for protection? Yes or no? Yes, sati keltiri sir. Sa keli sir yavado ondu. Okay, fine. So if it's take, the 7 automatically can go for protection because as it is, if you see, you may feel that it is very new and it can go for protection. Okay. So now come to the point of how we need to know whether any designs are available in the market or not. Okay. So for this, you need to do a simple prior art search. So however, in the patents you do in the similar way, here also you need to do the patent search based upon the company name, title, date. Okay, so everything, it is very common. And for this, if you go with the Indian IP website, there also you can find. And if you go with this particular WIPO design database, here also you can find the differences. Okay, so just observe few designs. Okay, so I was very curious about finding any masks are available. Masks have been patented, design protected. Okay, because most of the masks which maybe you heard that recently one of the fellow from North Karnataka, I believe, he found out a mask which can, it's a biodegradable mask. If you throw that particular mask, okay, so where it can regrow, like some kind of seeds they had put into that particular mask, okay, which can act as a scientific mode. Okay, if you throw afterwards, after using, there will be a grown for some species in that particular mask. There's a new innovation. Okay, but however, that will have eligible for some kind of a patent. Okay, but here in the masks, basically it deals with the designs because the appearance of the mask. Okay, most of everything we have N95. Okay, the cloth, cotton, other synthetic material masks. With curious, I just found out, okay, few are very unique, like this particular mask. Everything has had design protected. If you say, just observe, we have a design number, we have a filing date, we have article name as a mask, we have classification under 24. Okay, so this is under 24, but this mask, the below one, 306532, this is under class 29. Okay, so because both are mask only, but they had been categorized, okay, based upon the uses of the particular masks. Okay, and maybe you know that a design can be registered in India. However, the design is also territorial in nature. If you protect in India, it will give protection in India. If you want an abroad protection, then you need to go and file abroad protection. So now from there, okay, so if suppose if you file a application here and you need to protect the same thing in the foreign country also, then the date which you filed here, okay, that become a priority date for you. Means you can get priority from the date of first filing. Okay, so these are the examples of some of the common things that you see. That is, a design can given as a whole product. For example, the JCB there you see. Okay, so the complete body of the shape of a car or the bike is protected under design registration, right? And here we have a tractors. The complete tractor can go for production. Okay, so here you can see the Indian Council of Agricultural Research. Okay, Krushi Bhavan, human chicken killing cone, some kind of used in the poultry. Okay, so they had found out this particular equipment and they made a design registration over the appearance of the article. Okay, so if you see the number, design number 84611. Okay, how the ball was very interesting, right? It looked like a half portion contained pomegranate. Yes, exactly right. See, you can provoke your thoughts. Okay, so if this can go for registration, okay, you can make this kind of articles. Why can't be a mango? Why can't be some kind of sapota? Okay, so like that you can generate the ideas, right? Okay, so this is one of the interesting things which I found. Okay, and obviously the wall mounted. Okay, so which I see, I mean, we are also had some registrations, and you can see here also the wall mounted hand sanitizers. Okay, which is unique because leg operated is common to everyone. Okay, we have seen a lot of things, but wall mounted operated one, it's a very rare combination. That's why it has got registration. Okay, so automatic printer you can see. Okay, so you can see a lot of foodstuffs here. Okay, the chocolates, the shape of the chocolate. Okay, I believe this kind of chocolate, maybe if you are, I mean, I have not seen till now. Okay, but it is filed in 2013 itself. Okay, so these are some of the very common designs. Okay, so if you take the shuttle, okay, the cock here, each company had their own kind of pattern, feather patterns over there. Okay, maybe it may be feather or plastic. Okay, the patterns over the particular cock will be different for other industries. Maybe you can observe very closely the Nivea, the basic, I mean, the famous basketball which we use a lot in every schools, colleges. Okay, we had touched this particular ball if you are a sports, I mean, if you gone to the field. Now this is also a design protected, the shape has been protected, right? And now come to the class 7, cooking appliances and utensils and containers. Here you can find lot of applications and you can design a lot of products for you. Okay, so this is a newly invented stove, burner assembly for combustion of DME. Okay, so LPG cylinders. Okay, right. This is recently filed by the CSIR, Council of Scientific and Industrial Research. They had a protection over this particular stove. Okay, now come to the different other categories like spoons. What's the advancement over here? Okay, a spoon which can be used for eating food stuff. Okay, if you see, we have electronic spoons, electronic knives. The complete shape has been protected. And another thing is, almost I mean, from if you see the database of the design, okay, so many of the applications are filing by the faculties now, cannot with the industries. Okay, so now they are also well aware and they are started filing the registrations over there. Okay, so now come to the procedure of filing design registrations, so which is also very similar to the patent filing procedures. However, you need to take form 1. So after filling the form 1, you need to represent like this. Okay, so this is, okay, sorry, I have missed the application format. Okay, fine. See, once you fill the particular formats, okay, so after filling all the with the formats, like you need to represent your picture like in different ways, like front view, back view, rear view. Okay, so top view, everything you need to mention. You need to take photographs and you need to attach with to the form, and after you need to submit two applications to the controller. Okay, so once it gone to the controller, it will take examinations. The formal examinations will be taken place. So after, they will observe, okay, based upon the condition, like a new, novel, and individual uniqueness of the product. Okay, so how it attracts the customers, everything. Okay, will be normal examinations according to the act takes place. So after that, it will be given a notice to you that your I mean, if it is accepted, fine, it is published in the journal. So otherwise, if it is not accepted, then you will get an objections where you need to compile the objections and you need to send back to the controller. So after hearing will takes place, so that if the controller satisfies all with your complainants, then okay, fine, you will get the registration. Okay, so this is how the registration takes place. And the one small difference for the patents and designs is that, see, if you file a patent, first it will publish. So after the evaluation takes place, after you will get the grant. But in the designs, it's little different, that first you file, then you will grant. So after it will be published in the design journal. Okay, yes. These are some of the standard fees and forms. See, application to, if you want to file application, 1000, 2000 and 4000 is the design. Okay, sorry, 5000 is the design registration. Okay, so we have a lot of things here, like application for extension. Okay, application for registration. So obviously 5000 is the designs for the startups. Okay, startups are a group of company or institutions. If you filing from the institutions, the 5000 is the maximum fees for you. Okay, and it is for one class, not for all, one class. So if you want protection for different classes, you need to file a different application. Now come to the remedies of the design. Suppose if somebody has infringed your design or copied your design, what are the remedies that you have? So there will be an in-term injection for this. Okay, so there may be some kind of civil cases and criminal cases will be taken place. Okay, so that we will okay. There are however, this is called as this is also called as an infringement. Okay, so if somebody copies, you can sue them in the courts. Okay, and you can get back the damages that you got. Right here, a similar case with the Harpic bottle design cap. So here, the left-hand side, okay, that's the plaintiff design, that is Harpic. They filed a case against this this Renegade Industries, that is Jeremy Pick. Okay, so they said that the bottle cap was copied by this particular Jeremy cap, and they are doing the business. Okay, but here, however, the court, I mean, you may have seen these kind of inclined nozzles in all the toilet cleaners, many of the toilet cleaners, right? So here the court observed and said that since, for example, if you take anything which throw on 45-degree angle, the projectile motion will be high, long. Okay, so obviously it will reach at a larger portion. So in the same context, here the inclination was given to speed up or to increase the velocity of the liquid. Okay, so based upon this principle, the court rejected this application and said this is a functional aspect and anybody can utilize this and they can do their own kind of designs. Okay, yeah. Now come to this. Have you found any difference with the two chips, one with lace and one with the Balaji? Okay, both have you found any small differences? Yes or no? If you, as it is, if you see the chips, okay, lace and Balaji rumbles. Okay, lace is, I mean, that's the Max company has selling the chips in the name of lace. Okay, the Balaji company was selling the same kind of chips with the name of rumbles. Okay, what do you see here? Does the chips having a similar structure? Yes or no? Fine. See, as it is, if you see, I found little difference. Okay, so where the lace chips have some kind of sharp edges, but here the Balaji wafers has some kind of other kind of small wave structures. Okay, so now here the court observed what they said that since, okay, here the court said the lace and comparing to both chips together. Okay, so the court assumed that there may be a copy of this this lace chips that the Balaji wafers make a small changes over there and they're selling the business. Okay, so that's why the court given interim injection to the Balaji wafers to stop the production of the Balaji chips. I mean, okay, so to stop the chips. So that's what happened. Still the case is going on here. Okay, so now come to this particular fellow. So this Mr. Hendy Sinto, he is a founder of KTBR, Kabab Turki Baba Rafi, like however the Baba Ramdev in our country. Okay, so with all the organic ingredients, owner of organic ingredients. Okay, so likewise here Mr. Hendy Sinto became a successful entrepreneur by utilizing this kind of IP tools, especially with the designs. So how? Here in this particular business, okay, the problem for him was, see, this is a business with the kebab. Okay, I mean, which means a meat selling company. Okay, so they make they fry the meat and they do sell the kebab. Okay, here they wrap with the tissue. Okay, so while eating the along with the sauce, okay, the people have a habit of, I mean, it become they need to eat along with the paper itself. Okay, so many times it was happened to us also. How, where in our childhood days, if you closely observe, especially with the Asha chocolate and other kind of chocolates, if you open the wrapper, okay, some kind, it is very difficult to open it, right? Okay, what you do, simply you just close your eyes and you swallow it, that's all. Okay, so this was happened in our cases also. Fine. For this particular problem, what he did was he developed some kind of a packaging system, okay, where he protected under the design. So this is the package that he developed. There's a cardboard package that he developed. Okay, so this is design registered, and now this product become very famous, and the problem was eliminated, of course. Okay, so now it has become very famous, and he is very famous in, I mean, he has ventured into all kind of business, and now he has in 8 countries. Okay, so with all the IP tools, now he has ventured into all kind of franchisee, research and development, all the things. Okay, so that's how, with the help of this IP tools, anyone can go, okay, can reach this kind of thing. Okay, so with this I conclude. Okay, so if you you have any kind of questions related to this, I can take it up now. Yes. Yeah. So if you have any queries related to this, I can take it up now. I can see some chat, or you can chat me. I mean, you can post your questions on the chat box. So let me see. Okay, so logos are comes under IPR, sir. Yes, of course. Okay, so the logos can go for trademarks, like your institution's logos, your company logos, all can protected under trademarks. Yes. Any other queries? Sir, good afternoon, sir. Kodandram, sir. Yes. There's the taglines of the companies. Yes, sir. Yeah.
Everyone, every listener.
Yes, sir. Sir, yeah, okay. We are here. We have a question that taglines of a companies come under IPR. 100% it comes under the IPR. Okay, so it comes under trademarks. Okay, sir. If no questions, then okay. So you can continue with the Kodandram sir sessions here. Okay, and you can inform the science faculties to kindly join with the Google Meet, so that Nandini madam sessions will be taken parallelly.
So I request all the science faculties to again resume back into the Google Meet, and the commerce faculties, management and language faculties can stay back here. So that parallelly again we'll be running the session. So science faculties, please join the Google Meet. Thank you. Please don't put P. Okay, only science faculties, not the commerce faculties. Commerce faculties has to put P only at 4 o'clock. Not now. Only science faculties, please put P and leave. Commerce faculties has to put P only at 4 o'clock. And science faculties are requested to kindly join back Google Meet. Okay, so we have here our eminent speaker who is going to speak on trademarks in connection with IP. So I request Sri M.J. Kodandram Sam, IRS Assistant Director Retired, National Academy of Customs, Indirect Taxes and Narcotics, Bangalore. So Sri M.G. Kodandram, IRS Assistant Director, Master Trainer of GST for CBIS, GOI, has contributed immensely to the field of training and capacity building. He has trained thousands of officers in the various departments, trade bodies, student organizations on direct taxation and related laws and procedures. He is a recipient of the Sanman Award for his outstanding service. As recognition to his great effort, he received felicitation as an outstanding faculty of National Academy of Customs, Indirect Taxes and Nasin at the hands of the Union Finance Minister Sri Arun Jaitley on 1st October 2017. He is the expert group for the orientation course on GST for PSUs formed by Fiscal Policy Institute, GOK. He is a member of the State GST Committee in the Federation of Karnataka Chambers of Commerce Industry, FKCCI Bengaluru. Sri Kodan Ram, at present now serving as an advocate and consultant, started his public service as an executive in CBEC in 1981, and retired on superannuation on 31st May 2018. With his immense knowledge and experience, he has been participating in multiple seminars and conferences. He has presented many works on taxation, IPR law, cyber law, FEMA, etc. He has also been a keynote speaker in various prestigious conferences. He is conversant with the latest changes in indirect taxation law, regularly keeps publishing his articles in various websites such as Taxongo, Ilocor Laws, Tax India Online, and KLJ journals and publications. He is a guest faculty in over 60 training institutes and management colleges. He has recently authored the book titled A Practical Guide to GST Practitioner Examiners. So we welcome you wholeheartedly, sir, on behalf of Seshadipram Group of Institutions, KCST Seshadipram IP Cell, KCST, and all our allied organizing bodies. And we request you to kindly enrich us and enlighten us with trademarks in connection with IP. Over to you, sir.
Good afternoon, everyone. Thank you, Shantanu ji, for your liberal words, and all my friends.
Sir, with your permission, I have only one question to answer. Okay.
Are you answering?
Yeah,
hello,
I am answering, sir.
Nagarjun.
Yes. Sir, here one faculty has mentioned that if the product functionality is the same but designs are different, does it need a trademark? No. Okay, so if both the designs are different, you can go with the design protection. No, not for trademark. That's all, sir. Yes, thank you.
No problem. I will answer one question on the tag.
Yes, sir. Yes, sir. Please.
Kindly note, it is not directly available as a trademark. It should be used as a trade dress, and when you go as a passing off, it can be a claim. Mere tagline in itself cannot get trademark unless you have registered it as because tagline is something which will not be permanent all the time. It may keep on changing, and therefore taglines are not preferred as trademarks. They are better to be taking it as a trade dress. There is no registration of trade dress, but once you give a package with that, with similar words, somebody uses it, then you can claim of passing off if it is identical. More of it I'll come during my lecture also, right? So good afternoon again, once again. I'm extremely happy to talk on trademark. I think a couple of months ago, I have spoken to another group of Seshadipram, maybe 3 or 4 months ago, I do not remember. Okay, but why trademark is called as a intellectual property? People do ask me, what is a great thing in that, sir? There is nothing creative in this. Sir, for getting patent, we struggle day in and out doing research. In spite of it, they will say it is not obvious, non-obvious. It is novelty is not there. There is no inventive step. If I have a design, they'll say no, similar designs are available. Very difficult to create a design which will impress the consumer. Similarly, any other like copyright, you know how much difficult to keep on doing those works, and then especially if it is a computer program, it's all the more difficult. But in trademark, it is very simple, sir. What is there in creative? And that too, sir, all other trademark or IPs, you have only limited period. Like patent for 20 years, design is 15 years, copyright is okay, no problem. It goes with the author. You are given life of the author plus 60 years, or in the case of publication, 60 years. But in the case of trademark, and GI, which I am not going to speak of. You give it a perpetual, permanent one every 10 years. You can go on reviewing it. Renewal is possible. And therefore, what is that important of a trademark to a product? This doubt will come to everyone. But after my lecture, you will change your version, I assure you. And it is not easy to go for a trademark. What the trademark does, when you know, and how to find out a good trademark, your approach will be totally different. And the valuation of a trademark is far more than anything else, I tell you, because it's having unlimited life. So with that in background, let me upload my PPT. Is my PPT visible, sirs?
Yes, sir.
Yeah, very
You
good.
have to go for slideshow. Oh, yeah, wonderful.
Now I am also get used to this from last couple of years because I am only become an online man. Earlier I used to be move around, but I am not having the luxury now. Okay. Anyhow, very happy. What is a trademark? You are seeing a trademark on my face also, you know. There are marks like this, whatever not, isn't it? Especially Sikhs, they have their own mark. Is it also a mark? It's a mark. But it is not a trademark. It is not for trading. It's for people to come together. You think of another mark. Elections are always going on. There are symbols, election symbols. There is a symbol of cycle. Does it mean that fellow will go on the cycle once we give him to governance? Or some fellow may have an elephant. And is it meaningful that elephants are ruling or these fellows will allow that kind of luxury to go on elephants? None of them. Then why that mark? You have seen the blooming of the Kamala or the hearth. All that, they are also marks, but they are not trademarks. They are party marks. Others are religious marks. You can think of this classifying a thing is there from time immemorial. It's as old as the mankind. So also every trader wants to identify his goods. Why? Let's look into that. What is a trademark? What is this here? You will all say, sir, it's our great Amul. Amul went to US and they gave this as an advertisement. Then they will show, you will know, oh yeah, it has gone to US. Means how you are able to look into the picture and identify it as Amul, not as a child. A lot of you have forgotten the apple, the fruit. Now, when I say apple, you will say, so sir, it's a computer. But you have not looked into the aspect why a computer should be called as an apple. Why Amul it should be called? Why not ice cream? Ice cream would have been a better brand name, trade name. Why they have not kept it? Means there is a science behind it, which we have to decipher today. Kindly wait. So whatever traits I'm going to tell, look into the range of the products they are having, whether there is any link. Again, you can see how it is easy. Now you have found out, yeah, it's very sweet. The expression itself, it doesn't have to use any word. It means Amul, butter is so buttery, you don't have to struggle. Means it shows you the quality. You can see here, they have a franchisee brand. What I'm telling is the Amul is only the trade name. Amul is only registered. But when Amul is used in different products and even their outlets, they can franchise. If somebody says, sir, we want to sell Amul, they can say, no, you have to have this kind of design. You should have this kind of In that also franchisee, this quality you should maintain, this kind of air conditioner you should have. Thereby, that also becomes a marketable product in addition to Amul. That's known as the franchisee agreements and the design of the shop and design. See, for example, Amul is registered. There, the other things, outward dress, they are not registered. But if somebody uses Amul or otherwise, but if he comes up with the same color, it's a trade dress because people think it is Amul. Sir, whether Amul, Amal, if I write Amal, A-M-A-L, whether it is allowed, sir, or any other name with the same baby, if I put it, whether it is going to be objected, all that we need to look in. Now you can see how the advertisement goes on. Now they have entered the international market fighting against China. Means world over they are moving, exporting it in very large scale. That is the message they are trying to give. We are fighting the China. Thereby they are drawing the attention of whom? You know well now. So my purpose of the talk is, what is the objective and purpose? Eligibility criteria. What are the types of trademark? You will be able to know because you're all around with trademarks surrounding you. You look into anything, yeah? What is the mobile trademark? What is the trademark of this? What is the trademark of this computer? What is the trademark of this water bottle? You are having trademark everywhere. Eligibility, what is the eligibility? How to register, I will not concentrate much because you know how to register patent, you know how to register design. The same shop, if you go, there is a pro forma fees and all that you can spend time. I want to spend quality information with you, so avoid it. You can log into there and know it. Infringement, I will concentrate. Then we will think of the way forward. Tomorrow I am coming. So here, trademark where it has fights in respect of digital society, I am not discussing. Tomorrow, how our cyber society is fighting against the IP and IP is not able to survive the onslaught of cyber technology. Those conflicts tomorrow we will address. So first thing first, the purpose of this is one man should not reap the benefit of the other. There is a genuine person selling Ray-Ban glasses. There is another fellow, Ray-Ban. But the folk who is illiterate, even literate, why illiterate? They will think, yeah, it also appears like Ray-Ban. Everybody think it's Ray-Ban. They start buying it. But what happens? They may spoil the business of the genuine man who is marketing it, recording it, paying taxes. This Ray-Ban, because he is doing a fake dudes, he may not sell it online. He may not give it on bill or invoice. He's trying to sell it in the black market, creating black money. What happens to the profit that arises in the black money? You know very well. It will go to anti-social element. And therefore, everyone, every conscious citizen should go for a genuine product. A genuine product against the registration will have R. If they have applied for it, it will be TM. Trademark is in process. More of it I'll come back to you. Again, Amul. Why? What is this Amul? Actually, there is a story how our great Korean who created the white revolution. Kindly read about it. We were starved of milk products when we got the independence. But here is a great gentleman who started the cooperative movement in the Anand of Gujarat. Anand Milk Union Limited. That's what he started. And he was in search of a trade name. Somebody said, sir, you have 4 words. You make an acronym, Amul. Amul also means Amulya, means something very important. Then he said, yes, I will have a trade name as Amul, and thereby they registered Amul. They created a white revolution and it became a revolution all over India. Even Karnataka's KMF is influenced by them. And today how KMF is protecting its brand name Nandini and how it is stimulating other related products. Even during COVID time, they said, we will give you healthy milk. We will give you a kind of a milk which will give you immunity. And sweets, all that they are able to go because of the trade name, because that has earned them goodwill. Means why one should have a trade name, why one should go for registration of a trade name. First trade name we will see, registration, why it is essential later. You know what, why do you make a product, why do you make a goods? To market it, to get more income, to get more profit. To whom you sell? You sell to a consumer. Consumer should get attracted by not only the quality of the product, you must ask your product again and again. Then where is the connection? There must be some connection with your consumer. How it gets connected? It gets connected with some symbolic words like Amul. Any brand name, you take it. See here is a symbol, brand name, peacock, but it is not famous. Why? Why he is calling this as peacock? You could have called it as glass bottle. Kindly think that line also. I'll come to that later. Because it serves 4 functions. Now, as soon as Nandini comes, your mother or you are sure of the quality of the milk. And whatever Nandini products are there, you will be able to identify, hey, it's KMF. Similarly, Amul chocolates, hey, you can give it to baby also. It's very hygienic. Source you are going to identify, means you will know who is the manufacturer, and manufacturer gets connected to you straight away. Quality, you are assured of quality. And advertisement, you have seen how Amul is advertising. I have given only one example. You can think of thousands of such examples, isn't it? Means it is a highway to connect the consumer with the Amul. Lot of MSMEs after the COVID came to me and told me, sir, our exports has come down. I told them, whether you have a trade name? No. Then how he will be connected to you? You were selling to international market. For him to find out that mark, it's difficult. Consumers have stopped because you have stopped supplying it. The dealers stopped buying from you. And now consumers are not asking the dealers in the other country. If you were to have the trade name, you could have continued. People would have said, I want monkey brand sweeps. Are monkey brand. What is this monkey to do with sweeps? You see the connection. How it is important to invent the trade name. So it is this kind of connection. Cycle Agarabatti. World's one of the best marks for Agarabatti. Cycle. Normally cycle means mental fellow, like that we think. You see this guy is using it as a worldwide name. So this is the benefit we have. Is it limited to only goods? Are you not using Facebook, Google, WhatsApp? Recently in the more news, the Twitter, then Coup, all of them are services. They are digital services. You have so many other services. Yeah, come on. Means the construction or any other person with his brand, if it is there, you will be straight away attracted. Means it is not limited to goods. It can go beyond the goods. When it can go beyond the goods, can it go to group of people? Can it go for some quality? We will look in. Is it only symbol or words, or can some picture can be there, some color can be there, any other thing could be there, anything else could be there? Then why, how to create this trade name? Sir, you have put us in jeopardy. Is it in isolation, trademark as a, this one to keep as a, this one, whether he will create it, the trader wants to sell. So he uses it as a medium to influence. See now, India brand. What is Make in India brand now? You must be able to tell me. Come on. The roaring of lion. Why they created the brand? What lion to do with India? They could have written only India, brand India. But they went for a animal which is to be the king of the forest. What is the purpose of it? What is the driving message there? And I'm seeing that whether international people will start buying it, or do you require to maintain the quality? Kindly note, merely brand name in itself has no purpose. You should have a quality product. You should have to continue to give the quality services. Together, if you are attached with the brand name, then you have made your business perpetually possible. That's the purpose. This brand you must be knowing, gentlemen. This is the soap your grandmother was using and your usage also. What is this? Sharaba. You have forgotten this animal. Probably extinct. I have never seen this. But this is the symbol of 100 years celebration of Mysore sandal soap. Mysore sandal soap is such a beautiful brand started by ex-Maharaja of Mysore with Sir Vimeshwaraya, who started the first industry of soap in India. Even today, it is the best brand, but they are not properly utilizing the brand. Merely having the brand or quality item is not sufficient. You need to use it with variety of things so that people start going for it. You see this Mysore sandal soap brand as against Nandini brand. Nandini guys are very well using it as a very good marketing tool. But here most of you do not know this Sharabata. So there the implication is the management should also try more products and try to place it in the market so that the trade name remains popular. Once nearly 70% of Karnataka and nearly 40% of India were using this. Today it has diminished. This is the advertisement they used to give. I think that's the perfect complexion. This is the story. I do not want to see another advertisement of another. This is how advertisements were made during those days, and it is done today also. Now we will come back now to our learning. Now you know what is a product mark. The mark which indicates the product. Service that indicates the service. Collective marks. Doctors have one mark, isn't it? Chartered accountants have a mark. What is that? You know very well. Cost accountants have a mark. GST practitioners have a mark. Every group of people in the profession, they have a mark. There, that is called collective mark. That can also be registered. You are using Agmark food products. Oh, I got the gold here. What is that gold? Mark of the gold. It's the hallmark. Isn't it? It means they are all certification marks which indicate the certification. They can be letters, numerals, anything. 7 o'clock blade. 7 o'clock, what to do with blade? As though it will not cut at 8 o'clock. You think of a crocodile indicating a dress material. It can be anything. It can be label, sticker, monogram. It can be color. It can be shape. It can be a smell. Smell, sir. For example, tire. Sir, tire is awfully bad to smell. If it smells like a rose, then it is a Sumo tire. Sumo tire have the brand which doesn't smell like a tire. Means the sutra for all this is, if a name or nomenclature which is not at all used by anybody, if you want to select it for your product or service, it should not define the product. You should develop it through advertisement, a unique way. Means it should be other than the product. It should be distinct from the product. That's what the philosophy I drove home. Secondly, nobody else, again, like prior art or in the design or anywhere, nobody else would have. Plagiarism in copyright should not have been used. You must be the first man to use it for that particular class of goods. Here also classification is there. You can see here, Nanjana Godu, Hallina Pudi, Pandit. Even now they said they are going to release it. The trademark started through industrialization. The first mark was in 1876 at Britain, trademarks. That guy on the 1st January, forgetting his New Year's Day, has spent the whole day on 31st night in the queue to get the first brand name, trade name registered. From there, the saga of trade name has started. In India, there is no dearth of trade name. Even this year, it has increased to 35% more. Means, unlike others, trade name has been used long back from time immemorial. I gave you the examples of 100. Another one you must be knowing here. Mangaluru Ganesha Bidigalu. You can see the beauty of brand name. Mangaluru Ganesha. Ganesha has been brought there. Nowadays, people are highly sensitive. It may not be possible to have the brand name of that sort. And I gave you the Nanjanagudu and Darjeeling. Sir, are they not GI? If people are having the knowledge of GI, we'll question. Earlier, there was no geographical indications. The geographical indications started in the year 2000. More of it, when somebody speaks on GI, you will get more inputs. So Nanjanagudu Hallupudi was now, earlier area name was there, still continues. Darjeeling is both GI, it is the first GI of India. See, Nanjanagudu Hallupudi, they are able to start it again in more vigor because their brand name has survived centuries. But for their brand name, if brand name were not to be there, they would not have been able to come back, make a comeback. This is how. So now you know very well, I don't have to tell you, it can be anything where you get connected with the consumer. Now you can make a wild guess of so many things. And that could be your trade name. Very easy to find out a trade name. But we always stick on to the myth saying that the name should stick on to the name product. That's the first fault number one we are doing. Don't keep describing words. You are going to lose the case. They will not be given as a trade name. Number two, once you give a trade name, you should give quality products and you need to publicize, give good services to the people. And it should remain in the minds of the people so that you can get the market attention all the time. See whether this lady, whether she gets sleep or not. Brands are around and she is satisfied with the brand. This is how this brand name works. And other no's are, don't use superlative soaps. Laudatory words and all cannot be used. You should not say descriptive words. Coffee shop, coffee bar. Why can't you call it? You see, so many coffee names are there. Coffee Day struggled for 10 years to get the trade name. Because of their usage, they gave it. But nobody can stop using the word coffee. You can also put a word Coffee Day. Nobody can question you. But today, because it has become a practice, they may object, saying that in usage it is there, it is registered after it became our usage, regular usage. But instead of it, they could have gone for better name, like you have other coffee brands, isn't it? Words, direct references should not be done. Geographical indications are not allowed. Confusingly similar words cannot be allowed. These are all not allowed. You know the reasons. I don't have to spend time on this. Sir, how to go about? Kindly look into a product which you want to sell. Then try to look into the people's reactions for the product and try to get some symbolic understanding for the product. And that name, you can keep it. That symbol, you can keep it. That strategy, you can adopt it. Means it should be distinct from the product. And shall I go with 1 mark? No. Have 2 or 3 in the panel. Ask the examiner to check all of them. And if they are distinct, then you apply one of them, you are sure of getting it. But if you go for one trademark, that may not get. Again, you may have to do the entire exercise. So this is how trademark has to be searched. Why? Means you can see here, Abercrombie test, we call it. There was a case, Dr. Judge Friendly gave this decision, and now it is being practiced all over the world. If the name is general word used for that product, it is not your unique way we can give, because others cannot use it. If I allow computer brand name to you, others cannot call a computer, so it will not be allowed. Then if you keep descriptive words also, they will not give you, because it's also being used. But if you keep suggestive names, you may get nearer to that. But if you keep some fanciful names, arbitrary names, something beyond your products, nothing, no connection at all, then you are sure. I think you are able to know why monkey brand has been given to sweeps and all other brands around you. You can do this kind of examination. This is where you should know the sutra of inventing a trade name and applying for registration. Once this is ready, filing the trademark in the registry, the fees and all you can see. It's the least charged amount, not much like a patent. Examination is similar to it. Publications is being done. Once prior examination is done by the office there, they will publicize 1 or 2 journal entries. I will show it to you, so that whether it's a good trade name or not, you will be able to discuss and understand, because this is a virtual one. I am not be able to get your responses. Okay. This is how, and it can be gone. This is the office, the address, World Intellectual Property. I always come late to speak to you. So most of my speakers would have given you all these symbols. That saves my time, makes my work very, very easy. Now let me move. This is the flow chart. When you apply, objections not waived, no objections, examination is done. They will publish it in the journal. If there is no opposition, they will grant. Post objection can also be there, and the fight goes on, and it will be a registered trademark. Nobody else can use it without your permission. Here, people do ask me, sir, how trade name is helpful? There was one gentleman came to me, sir, this is the molecule X. I had taken the patent 15 years ago. In another 5 years, I will lose my market. What shall I do? I asked him whether you are using any trade name. He said, no. You start using your trade name. After 5 years, you have already lost 15 years. Doesn't matter. Next 5 years, you popularize not your molecule, popularize your brand. After 15, 20 years, no doubt the technology is available to others. The product is available to others, but your brand name is unique. By the time if you have established your brand name, you can have established ruling on the market. So this is where trademark can be a better tool. Sir, I don't have a product. Can I do it? Yes, you can do it. And if the product, the trade name is very attractive, people may hire it. In fact, when I spoke to my office, my students in Gulbarga, not Gulbarga, I think Belgaum, that college name I am forgetting, very attractive, Gogte College. There were a gang of 2 or 3 fellows started coming and hunting me in the evening. I told them, what is this? Sir, we want to talk secretly with you. Secretly with you. I said, what is that secret? Come on. Then the chat started sit in the park and started discussing. Sir, we are coming out with a product. Now we are having a very good name for it, sir. Can we apply it? I looked into their product and name. I said, name is very attractive. It doesn't define the name. It doesn't suggest the name. It's beyond the name, but nobody has used this name. I can make out. Anyhow, you can do the search and you can apply. You can keep it. Sir, it will take 6 months for us to come out with the product. I said, doesn't matter. Once you register for 10 years, you can wait. So that's the beauty of trademarks, right? This is how you should. You see the number of trademarks registered. It goes long. Even it has become 30% increase during the COVID. See, the quality of services has improved. Our earlier speakers might have told how much time it was there for patent, and as on today. In brand name, recently I saw a guy who got the brand name registered within 3 months. So then it's a better success story. I'll go to journal entries. Till now, whatever I have spoken, to stop the monotony, I want questions if you have any. I think I will open the chat box if possible. More. Somebody can open the chat box. If there is a question also, you can say, read it for me. It will help me. And please ask questions. I want to ask you the questions. I have driven home the point, what trade name is and how to select a trade name. Now we will look into the legal aspects of it. Any questions? Professor, students, come on here. Put me in trouble. Guys, hope you are not sleeping. Okay, let me move. Don't worry. Here is some journal entries. Here is gentleman, Master Chef. This is a trademark he applies in class 29. Class 29 has meat as well as vegetarian. They are mixed to both of them. See these guys. Okay, don't worry. It's an international system. More of it you can read. I have written a lot of articles in the Karnataka State Chartered Accountant Association. A series of articles on IPR I am writing to help the MSME. Kindly download them. It is available and read them. Here, Master Chef, it's given to a product. You can see the trader's name, product's name, a new, where exactly it is there. It is for edible oil. Master Chef, it may be a kind of a suggestive name. Master Chef means something to do with cooking, but still you will get it because nobody will have this as a brand name for an edible oil. So it's a very good brand name. And see the good morning. Good morning is for mustard oil. Fine, no connection. Kajol for eye. Very difficult to get. It is describing the product. A lot of people use this word kajal regularly. Sir, good morning also use. Nobody will use good morning for a edible oil, man. Good morning means good morning, isn't it? But kajal means kajal, something to do with the eye. They may not get it. There may be opposition, or somebody else calls it as kajal. And if you make a case saying that it's my registered brand name, they will say kajal is a common name. You will not get it. Laukush. Laukush for coffee, tea may appear something distinct because it is having some religious feeling. They may get into trouble later on. Or it is not viable. Can they not go for better name for coffee, tea shop? This is where you need to do a little thinking. Taste and tell. This is okay. The suggestive name for a bread. Taste and tell. Nobody will think that it is connected to bread alone. Later on, for a lot of eatables, it can go. And nobody will have taste and tell as one with that symbol. It may be given. Desi bread. That's the tagline. For that, it is not there. Only for taste and tell is there. If you apply for Desi bread, again, bread becomes a common name. There will be a dispute. So they will say, if you apply for taste and tell, you will get it. If you put desi bread, we can't stop others from using it. But if you put it on toto on the product, you will be treated as a trade dress and you will get protection from passing off. Protection from passing off under common law, but trade name registration under infringement may not be possible. You can see here, Turant for tea, wonderful name. Turant is nothing to do with, it's something like urgent. Probably it's an instant tea. Turant, hey, Turant de do, wo famous ho sakta hai. But here see Hari Veda. Are yaar, we guys are using this Veda for so many years. He wants to call this product as Hari Veda as though no new product is possible. Herbo care, that too. This cannot be registered. Very difficult because we are having a lot of words ending from Veda, products being sold connected to the herbal products. Can he not think of new product? I am telling him to look into the wide arrangement of things possible. When God has created this universe, there is not even one fellow who is identical. You forget one fellow fully identical with the other. Your 5 fingers are not identical, isn't it? And even the prints on the finger are totally different. Such a variety is possible. Such a variation is possible. Is it not possible to find out a brand name for us? Though we are limited in knowledge. This is where we need to chop. A lot of people come to me saying, sir, it will explain my product. I told them, you will fail. Here is a fight you can see here. Here is Matru Ayurveda. Matru Veda. Now, I will open up the question. You have to answer me whether they are phonetically similar, whether they are infringing others' mark. That's my question. Say yes or no. Somebody there can look in and tell me what is polled there. Or somebody can open his audio and speak to me. Whether this brand is identical brand, phonetically similar or not. That's the question for you. Answers, please. I opened the chat box also. Sir, does tagline and trademark come under same registration process? If you fix it with the trade name, it will be taken up. But it is not advisable because if it is having common name, again, you will get into trouble. How now you see how this Ayurveda, Mathurveda has got into trouble. We will see. Okay. Any other? Kindly tell me. I am seeing chat box is empty here. You guys are sleeping. Yes, yes, good. Some more questions. Come on. Yes, sir. Yes, sir. Good. You people have not studied trademark properly at all because recently there is a case of Nandini versus Nandini. I'll come back to you. I'm happy you guys are still awake. We were here. Are you able to see my PPT?
Yes, sir.
Right. What you said is they are phonetically similar from your voice, but court says they cannot be. Who should be finding it to be identical? You are in the Lakshman Dara and Amrut Dara, where fellow will come for a medicine and they will buy. Even something else is given, he is in a hurry, he will not see whether it is Lakshmana or Amruta of Shiva period or Rama period, they will take it, fine. But when you go for pure natural indigo powder, as a consumer, you will find out, hey, it's written Matru Veda, yaar. It is Matru Ayurveda. The color is different. The outlook, trade dress is different. Here, trade dress is different. Here, mother's wisdom is here. The tagline is not there. Mother is also not there. Anybody can make out. And the fellow who is buying indigo powder will not be in a hurry. In fact, they'll be more careful, especially ladies. They go on, forget about the bargaining, finding out the product. They are very investigative skills. But everybody like you only thought, and in the trial stage, when plaintiff Matru Ayurveda requested, the trial court gave injunction saying that the defendant cannot use it. You can see the plaintiff contended she is going to business under Matru Ayurveda. This Matru Veda is spoiling my business, and it stopped the brand name being used. So immediately he went to High Court. High Court took another view. Gentlemen, just because it is Matru Ayurveda or Matru Veda, who is your person buying? Whom you are going to connect with the trade name? It is the consumer. Whether consumer is misled now, even highly uneducated you may call him, he will make out, hey, that color is different, this color is different. Hey, oh, alag, he is having some other symbol. This will have some other symbol. It cannot be identical. So court said, merely just because words are phonetically similar, they are not infringing. They are not passing off. It removed the injunction. It said, Mathur Veda with 2 leaves spread, it is there. Here, Matru Ayurveda is having some other stylized manner is there. And entire image was set on a plain green background where the other one is at the another background. And he says, whether trademark defendant was deceptively similar, he said, no. Trademark is totally different from trade name. Trademark is that mark. That's what I was telling you. Trademark is used in the trade name and the entire picture. And it said, it is not. It said, sir, whether there is any likelihood of confusion arising. Sir, some people may go. Then he said, this is quintessential common man is neither blessed with the wisdom of Solomon nor trained in the eyes of Sherlock Holmes. So don't think common man as a Sherlock Holmes and he will buy maybe that company and all that kind of thing. It is not. And therefore, in the newspaper recently you might have seen, courts should keep in mind common man, not Sherlock Holmes, while deciding disputes over deceptively similarity in trademarks. Karnataka High Court. This is having the basis of Nandini. Nandini is a very famous came of mark known to you. There is a chain of hotels came Nandini. Everybody thought that Nandini is, this is also Nandini, and Nandini came of put a case. Up to the level of High Court, they said phonetically similar. Supreme Court said, whether this Nandini fellow who buys milk knows this Nandini is a hotel, chain of non-vegetarian food. Yes, he can understand. There is no phonetical similarity. It gives this test of 7 principles. Merely if they phonetically similar will not. The trade dress should be similar. Thirdly, most importantly, it should be confusing from the eyes of the consumer. I told you trade name is there to get connected to the consumer. If the consumer is in a confusion, it is possible. There is one more brand here, one more case. Scotch whiskey and the another that is our Codes, not rum here. Codes some Peter Scotch. Codes were having Peter Scotch, which is an Indian made foreign liquor. The Scottish companies, sir, people will buy it as a Scotch whiskey. We are going to lose the market. They filed a case. Court asked one simple thing. Sir, they will be drunk. Consumer will not be able to know. What is the cost of your one for 30 ml? Sir, it is 5,000 rupees. What is the cost of this? 100 rupees. When some fellow asks for 100 rupees drink, will you give 5,000 rupees drink? No, sir. The fellow who spends 5,000 for the drink knows which is that brand which is using. He says, is it original Scotch whiskey? He will, if you say Peter's Cut, that's Code's Cut. He knows it, yeah, and hence it is not phonetically similar. We will not give. These are all very interesting cases where you should drive home whether merely prima facie listening is similar cannot give you the protection. It is from the consumer angle, whether confuser is put into confusion. That's the idea. You can see here, teach and inspire for an educational institution. Not that good name. They may get it, but others can also use it as teachers. Teaching college, teachers college is already there. They may find the objection. Inspire, always teaching is for inspiring, not making you sleep. But see here, this guy for a kind of a kindergarten has dots. Wonderful brand, I tell you, dots for a kindergarten school. It has nothing to do with that, but dots means the beginning, or is it an end? We do not know. Kindly look at it. So this is how creating a trade name should have an impulsive knowledge. It need not be suggesting the name. Here is how brand names can give. Here is the story. Who is she? She is known to you. She is Himan Das. Wherever she ran, she got only gold. But unfortunately, she is ailing now due to some injury. May not participate in the Olympic. Otherwise, India would have been sure of a gold. She is from a very, very medium background. In my first nationals, my father bought running shoes and I wrote Adidas on them with my hand because the affinity towards brand. People, all the people runners are running with Adidas shoe. She is running with an ordinary shoe, but she also should get that pride. See the inclination for the brand name. Adidas is now making off. She won the gold. Now Adidas itself has changed the name. It is coming out with Hima Das. See this. How brand people are playing with the masses now. Now they are coming out with Adidas and Hima Das for India. People are buying Hima Das, and she got a very good sponsorship. She got very good royalty also. So this is where the business should think and move with the product. Then only there is life. Then only they can cling on to the business. That's that. So that's the golden girl. You can see here. I used to go around. I used to feel afraid of drinking water, and that bottled water is even more difficult. I used to take this tender coconut placed in a bottle. How beautifully he has made. I may pay 10 rupees more, but it is comfortable for me when I'm traveling. The tender coconut, which is sold at 30 rupees, I may get it at 40 rupees, but I'm comfortable wherever I am in the journey, I can use it. But it is not limited to. You can see an ordinary product can be sold extraordinarily. Here, this design is registered. Trade name is registered. He has called it as raw. It is not called as coconut. There is another thing, Soukia. You see the shape. He has the design for that bottle opener type. He started having a machine which will cut the coconut itself into that shape, and it will embed an opener. And this can be used wherever you want. It can be kept in the fridge. It can be used in the meetings, in the corporate halls. Nowadays, they are serving only Soukia. He started grated coconuts using wherever he cannot bring it to that shape. He started making it. He started making a lot of products with it. Soukia is the brand name of them. He never used coconut. Today it's one of this best-selling mark. Now, here is a fellow. This Goa, somebody told that if you make tea out of the leaf, it's the best tea, which is organic tea. And now he's making a very big business. Means something which is cannot be sold, which is simply thrown away, he is making crores of rupees business. How this is possible? It's because of the trademark and the quality he started maintaining. So friends, whatever I have spoken is available in this picture. Trader gets connected to consumer, consumer in turn with the trader, with the trademark being registered as the highway. It is the super highway. It's a business idea. It gives identifier of the business. Here it is identifying the quality for them, and they can rest assured of buying that product. And this is being recognized by the government if it is used by you alone. Unique, no prior art. And you can apply. If you don't register, if you are the first user, still you will get it. But you have to prove in a court of law that you are the first user. So that's the theory. Now, agriculture is, they say it's getting diminished. In fact, agricultural products are very well done. Recently, GI, around 6 tea products, coffee items got it. One of them is Baba Budungiri. In fact, in India, coffee was grown in Baba Budungiri, but they never registered as a GI. No, only they have, in 2018, they have registered. There is a story behind it. The coffee board people used to call me and say, sir, all agriculturists scold us. They don't want us. I told them, you want to take a cut from their profit, so they don't want. How you are helping them? Sir, how we can help them? I said, why don't you make it an organization? Why don't you create a brand? It did not strike to them. Now they have come out with a Baba Budungiri and say, we are having a GI. I told them, this is too late. You have lost. People have spent 300 rupees or 400 rupees per ton to outside India, the coffee. If the brand name were to the way, that could have been 600 rupees, 800 rupees. You would have gone fetched more marks and the farmers would have been more happy. So there, using brand name, you can popularize the products. You can have a set of farmers growing for you with that brand and that quality. World, year over, you can buy it on that rate and you can do it. That's very, very important. Now products are reformed. Their products are also coming, and thereby the marketing people should invent new names. The other things are not important for me. For us, we must be able to sell the product at a premium price by keeping quality and the brand. And we should see that there is a perennial business for it. Then only Vande Mataram, Sujalam, Supalam is possible. Sasyakana. You can now, we'll see 1 or 2 infringement cases. So now trademark means it gives you reputation, it gives you goodwill on goods and services. How? All that I have shown you through your own experiences till now, examples. So the criteria to select is, it should be distinctive. Once it's of your own use, known usage by you only. Non-descriptive, it should not explain the goods or service or anything. This is not applicable to collective names, kindly note. Non-deceptive, it should not be similar to some fellow's name. Not confusingly similar. If it is all happens, you can register. It's valid for 10 years plus 10 years plus 10 years. It can go on for hundreds and thousands of years. Here is a name, Dettol, the most famous name. There is another fellow, Dettol. Whether they are phonetically similar, not only phonetically similar, the trade dress is also similar. Court said you are infringing the trademark. Here, instead of Dettol, it's a very good product. You could have kept any other name instead of passing off as Dettol. He has tried to pass it as Dettol, and thereby he could not prosper. He got the hit. Court has fined him. All those details are available. Similarly here, Candid B is a very good medicine. Some hospitals were using it. That hospital started making Clodid B. Sir, Candid is different, Clodid B is different. No, they are, trade dress is similar. Court said you cannot use it. The formula is the same. So there you should have the wisdom. Otherwise, this fake business, I can go on. If time is there, I could have given hundreds of such pictures. Okay. Another Cadila Healthcare. Cadila, here the principles were given. Kindly look into this case study. The theoretical part I will not give. The item is Falsigo and Falsitab. They're deceptively not similar, they said. Sir, they're phonetically similar. They're all Schedule H drugs advised by the doctor to be used by the doctor at the hospital only. It is not a over-the-counter medicine. And doctor knows what is falsitab and falsitab. So there, that kind of differentiation is there. Colgate and Anchor, sir, totally different, phonetically not similar, but they are taken out as passing off, trade dress. They look alike. People, when they ask for Colgate, if you give Anchor, hey, same name, Ray, name company, Ray, not Ray, one day tara ide, like that they can pass it off. That's passing off under common law. Kindly look into this case study. Here is another one. Ram Dev is Ayurveda Pandit. That Ram Dev, who doesn't know? He has certain units who are licensed to export, others only to do in India. The guys who are doing in India wanted to export. He said, you cannot export out of India. Only those licenses I have given for exports they can do. There is no question of allowing. This is just opposite to parallel imports. You can call it as parallel exports. Though it's the genuine brand, only being permitted by the company can be exported. That's the case study. Kindly look into this. These are all academic aspects which you can study later. Cyber squatting I am taking up tomorrow. Today I will not discuss. Kindly remember that one. Here is another ISKCON versus ISKCON. ISKCON is a well-known trademark. Somebody wanted to have it as a trade dress. Court said no. Sir, ISKCON, everybody knows as a temple. Dress, no, you cannot put it a dress. It amounts to a kind of a demeaning. Like one of the underwear manufacturer, undergarment manufacturer, kept Benz. You might have seen that picture. They said no. They said, sir, I'm not using Benz. It's not a motor vehicle. It's a crores of rupees worth vehicle. Yeah, that's crores of rupees. You cannot put it to undergarment. It means demeaning. So even that situation is possible. Friends, the negative effect is undermining the innovations, value creation, fall in exports. All this is happening. Kindly stick on to the brand name, trade name, move any product to the market with a trade name so that you will avoid counterfeiting. Don't buy counterfeiting goods. Don't encourage counterfeiting, and you start branding your goods and start teaching the students also to go with the trade name when they incubate. Then there are remedies, which Mr. Nagarjun was also telling. You will hear more about the remedy in a separate class. There are civil things and passing off. Tomorrow I'll take up one study of John Doe order, Reliance company case, and the rest. I do not have time. Friends, now you know why a trade name is required. It's having economic justification. Your product value can go up. It has the quality, consciousness developed. You have to keep that quality. Then only you can survive. It has the social status. It is easy for you to advertise, to read the product, like trademark, transparent trade protection, make in India. This is the saga we are on. So it's think, create, inspire. Let's take India higher. That's the message. Here are some websites. Friends, till now, we have looked into objective, purpose, eligibility, how to select. On all these, I have written very intensively in the Karnataka State Chartered Accountant Association, KSCAA, their regular magazine. Last month, I wrote on traditional knowledge, how it should be used by the MSME industries. Our own knowledge, traditional knowledge, how it should be exploited, commercialized. On that I have written. So I thank everyone. What I know, I have tried to share. But the truth is, all I know is I do not know anything. But don't have ego. Ask anything with everyone. Everyone is wise. Get into that and be humble. Leave the ego and make India strong. With this, I complete my talk. I open up for question answer sessions. There must be some interesting questions by this time. Any questions?
I request our esteemed participants, delegates, to kindly ask questions. Pavitra madam, just put P repeatedly. Don't put your name and your institution. We had been repeatedly telling, first put questions, let our speaker answer all the questions, then put P. Request everyone, if you have questions, please ask.
Have I reached you?
Sir, you have, sir, there is a question. What is the impact of trademark on upliftment of SMEs?
SMEs, yeah. See, as a businessman, you want to reach your consumer all the time. The first principle I tell SME is, you do not know how to connect with your person. For example, there was a lady who met me nearly 1 year ago. Sir, from 3 years, I'm struggling to sell this pickles. I am not able to sell. I asked her, is there any brand? No, sir, I'm having the picture of Lakshmi, I'm keeping it. What is the harm in creating your brand name? Sir, whether I have to spend, she is already 60 years young lady. She had his family fully backing. She said, sir, I wanted to do something and I want to do it. Then I said, you invent a name. She listened to my lecture. After 3 days, she wrote to me, sir, can I keep 4 or 5 choices? She gave, I told them, these 3 or 4 you can apply. She got the trade name. Today, she is not MSME. That's all. You will not remain MSME. You will outgrow. She says, all my people, my sons who are working for 30,000, 40,000, they have started working for me, sir. Now you know the change. She is able to export within 2 years. How? I do not know the answer. You must be able to know. Means the consumer who takes it will start coming to that brand. There will be repeated thing and he will go on by word of mouth telling to everybody. By telling that name to so many other people. Just now before coming to you, I was listening to Devi Shetty addressing our GST meet. He was telling the most powerful people are women. And he was requesting the women, when workers come to you for household works, tell them to get vaccinated. That's the best publicity. Here, same thing has happened. Hey, this brand is good. They are going to tell. And when they go abroad, they'll say, this brand is good. And those fellows say, do you have this brand? They will ask them. They will buy it from here. Means, he said, sir, you have changed my life. I said, I have not changed. It's the trademark and your inspiration at the age of 60 to do something good for the family. That has brought the laurels. That's a traditional knowledge known to you, given to you, your great grandmother. Today you have flourished because of the knowledge. If it has gone with you, it would have gone empty. This is how I always say, when an elder person dies in a home, entire library is burnt. You need to acknowledge the skills of ancient wisdom and preserve it. Now you know how trademark has changed the MSME. You don't require further description, I hope. I think I have answered you, sir. Any other questions?
Sir, is there any valuation process for trademark?
Yes, valuation comes later. Any intangible item can be valued only when it starts driving revenue. You have a trade name, you have started making your product. In other places, you are not able to sell your product. At that time, you will give it for licensing. This lady may, instead of exporting from here, may get the raw material if it is available, get an industry set up in other countries also. There, that fellow may use this as a brand name. There, it starts giving the revenue. Means it is an asset. It will be a liability if you don't commercialize any IP. If you commercialize, once it starts giving return, once it gives the goodwill, then it has assets value. And valuation, there are 3 methods. I do not have time. You call me for IP and valuation separately, I will deliberate. Now I am working on a project on data, personal data and valuation of personal data. So we have gone far ahead on valuation of assets. And if you look into AS 28, if I remember, Accounting Standards of Chartered Accountant, They have standards already from last 15, 20 years. But the only thing is in trade name, it fluctuates. The valuation may be very high and it may come down very quickly. So people are afraid to give it as loan for a guarantee. For example, you know what happened to Kingfisher. Today, what is the value of Kingfisher brand? Nobody is there to buy. Earlier, what was the goodwill? So there, certain intricacies are involved, and it's a wonderful question. I thank you for the question. I have provoked you. Kindly arrange another class, valuation of IP products and such virtual products. We will discuss it in a separate forum. Any other questions, sirs? Ask questions, gentlemen. I will also learn from the younger folk what is the things going on. Otherwise, sitting at home, I will rotten myself. If there are no questions, we can ask the next speaker. You may be having next course. I do not know. Kindly, you can do it. Go ahead. Any questions? Shantanu Das, you're muted. Yeah. If there are no questions.
Last question, sir. What are the consequences when any famous personality name is used as trademarks?
It is not allowed. Simple as that.
As in small scale business or local shops?
No, they can use it limitedly. If the advertisement is made more and the famous fellow comes to know, he can sue you. That's why don't get attached. You are deceptively trying to make it similar and trying to encash as passing off. Never do indulge in that. World is big enough, gentlemen. You have huge way available. Is there any struggle? Akasha nodakke nuku nuglenre. Bekadashtu akasha ellinda bekaru kanutte. ನೀವು ನೋಡಕ್ಕೆ ರೆಡಿ ಇರಬೇಕು. The sky can be seen from anywhere. That you don't have to struggle to see the sky, but you should have the intention to observe the sky. There is no limit for your growth. If you do not struggle to make it happen, then it is like this. The girl lady which I gave you the example of pickle, at the age of 60, she has struggled and make the entire family come through of the woods. This is how you should be different. You should be an entrepreneur, or you should create entrepreneurs who will use all these tools. Research they will use, their quality products they will use, even for research. Don't do research for the sake of research. You find out the gap in the consumer. What consumer wants as on that day? What is his requirement? Is there already an invention available? Use a brand name and bring it. Why do you struggle to invent again? Why do you invent the wheel again? If it is not there, then you concentrate your research towards that. That research where you fill the gap will bring the consumer. Then it can become popular. For the sake heck of it, if you do research, it has no commercial value. So that's the message I wanted to give you. Any other questions?
Yes, sir. Thank you so much for your extensive and elaborate. So hope you know tomorrow you come early, sir, so that no it will have instead of the last speaker. It's always better you come early, sir.
I'm coming tomorrow at 12 o'clock. You
Yes,
want
sir.
earlier even?
Tomorrow, let me see. Yes, correct.
12 to 1.
Yes, yes, correct. Correct, sir.
Yeah.
Correct. Thank you so much, sir, wholeheartedly.
May God bless you. Sarve jana sukhino bhavantu. Please
Thank you.
be
Thank
safe
you.
wherever you are.
Thank you so much. We request you to stop sharing the screen
Yeah.
so that we can see you in a big scale. So the same link, I request all the faculties, head of the institutions, my dear colleagues, and all the delegates that tomorrow the same link will start at the same 11 o'clock. And tomorrow will be the penultimate day, and whatever we are learning yesterday, today, and tomorrow, there will be a case studies and quiz based on that. You will be getting the certificates.
There was some disturbance.
Yes.
It went off. Now I have come back to you. You can share anything else you want to. You were telling something and it went off all of a sudden.
Yes, so that's what we thank you wholeheartedly on behalf of Seshadipram Group of Institutions, KSCST, Seshadipram IP Cell, North Bangalore Science Forum, that you have taken so much pain and effort to guide us and share all your valuable experiences. So we are indeed privileged and indebted to you for your knowledge sharing. Thank you so much, sir.
Tomorrow we will have a very enjoyable time. We will sail with the digital technology and IP. Then there will be a conflict. We will enjoy tomorrow. Thank you.
Thank you so much, sir. Thank you. Thank you, sir. So I request all the participants tomorrow, and I request our principal sir to speak a few words before we close for the session.
See, I'm thankful to each and everyone for participating this, and thank you, sir. Your valuable words definitely inspire us, and thank you, one and all.
We in fact thank you, sir, for your kind patience, guidance, and helping us to listen and get all those knowledge.
Thank you,
And
thank you.
I request all the delegates tomorrow sharp at 11 o'clock with the same link to join for the penultimate day, and the last session will be quiz and other questionnaires. So please be ready with whatever the information gathered and whatever the information shared. So there will be all those extensive workshop tomorrow. Thank you. Thank you one and all. Stay safe, stay healthy. I have shared the feedback. Please fill the feedback form and put P as a presence, and then you can leave for the day. Hope everyone has marked their attendance. So can we close the session? In another one minute, we'll close the session. So please put your attendance, respected teachers.